We're on the record in the matter of the state of Georgia versus Antonio Sledge in 22 SC 183572. Good afternoon, Mr. Wright.
Good afternoon, Judge.
Good afternoon, Mr. Sledge.
Good afternoon, Your Honor.
And good afternoon, Councils Love and Hilton. Okay, Councils, I understand this is supposed to be a negotiated plea. Is that correct?
That's correct, Your Honor.
Yes, Judge.
All right. Mr. Sledge, can I get you to raise your right hand as best you're able?
Yes.
Do you solemnly swear or affirm that the evidence you shall give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God, or so affirm?
Yes, I do.
All right, you put your hand down, sir. All right. Mr. Sledge, over the next several minutes, what's going to happen is we're going to go through such a thing called the providency inquiry. So basically, in our system of jurisprudence, we don't force people to plead guilty. So I have to be assured you understand your constitutional rights and that you freely and voluntarily waive those rights so I can go ahead and sentence you. The second thing it does is we go through a factual basis, and I determine if there's a factual basis that the state would have been able to prove in this case beyond a reasonable doubt had they tried the case. So assuming that I find that you understand your rights, we call it the Boykin inquiry, and then the second thing is then I find that there's a factual basis I can accept your plea. So, ladies, which one of you is going to do the plea?
I am, Your Honor.
All right. Ms. Love is going to go and ask you a series of questions in just a minute. And then your attorney, Mr. Wright, will follow up with that. And then I'll ask you a couple of questions, and I should be able to sentence you in accordance with the negotiated plea, okay?
Yes, sir.
Okay. All right. Ms. Love, whenever you're ready, madam.
Thank you, Judge. Mr. Sledge, please state your true, correct, and legal name.
Antonio Sledge.
And are you the same Antonio Sledge, also known as Moontum, who is listed in indictment 22 SC 183572?
Yes, ma'am.
Are you at this time taking or under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 41, 10th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the following offenses?
Yes, ma'am.
Conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act,
Yes, ma'am.
as well as possession of a firearm by a convicted felon,
Yes,
as
ma'am.
listed in count 30 of this indictment.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges, and that if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney, Mr. Derek Wright, about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Do you waive a formal reading of the indictment?
Yes, ma'am.
Do you waive any and all defects in the indictment, including any with respect to your name?
Yes, ma'am.
Have you been arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Do you, Mr. Wright, know of any outstanding warrants that are related to these charges?
I do not.
Mr. Sledge, has your attorney advised you of the minimum and maximum sentence for each charge that you are pleading guilty to
Yes,
today?
ma'am. Yes, ma'am.
Do you understand that the minimum sentence for conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act is 5 years and the maximum is 20 years in prison?
Yes, ma'am.
Do you understand that the sentence for violation of count 30 of this indictment, possession of a firearm by a convicted felon, as in OCGA 1611-133, is 15 years in prison.
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty,
Yes, ma'am.
which means that the state will recommend to the court the following sentence:
Yes, ma'am.
as to count 1, 15 years to serve on probation, subject to the special conditions contained in the plea agreement that I have in my hand that I will show you in just a moment. And on count 30, although you are pleading guilty, sentencing will be withheld until the completion of the initial trial of this case. After the initial trial of this case, provided defendant you have complied with the special conditions outlined in sections B, C, D, F, and I of section 3, special conditions of sentence of this plea agreement, the state agrees that the defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. Do you understand that the court does not have to accept that recommendation? And we will read into the record the terms of the plea agreement in a moment. Do you understand that?
Yes, ma'am.
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other if the court does not accept that negotiated plea?
Yes, ma'am.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today, but that the state is not recommending either?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that this plea involves your being placed on probation, and that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special condition of probation without being subject to revocation for the balance of the sentence? Do you understand that?
Yes, ma'am.
Do you understand that you are not allowed to use or possess a firearm while on probation?
Yes, ma'am.
Do you understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, just like a conviction at trial would, and that this is true regardless of any advice given to you by your attorney or anyone else?
Yes, ma'am.
Do you understand that if at any time you are sentenced to confinement based on this sentence, neither the court, your attorney, nor the district attorney's office has anything to do with parole, and that in that circumstance, the Department of Corrections or Board of Pardons and Paroles
Yes, ma'am.
are the only persons who can address parole, and that no one can guarantee parole no matter what anyone has told you?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, and your right or ability to obtain employment. Do you understand that these rights may be affected?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of another felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself.
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand that you are giving up all of these rights?
Yes, ma'am.
I'm showing you what has been marked as State's Exhibit 1AS. Do you recognize the document in State's Exhibit 1AS?
Yes, ma'am.
And is that your signature on page 7 of 7 of State's Exhibit 1AS?
Yes, ma'am.
Your Honor, at this time, actually, and Mr. Sledge, have you had an opportunity to review each and every provision within State's Exhibit 1AS?
Yes, ma'am.
As reflected on State's Exhibit 1AS, the current charges that you face are count 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, and count 30, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm, OCGA 16-11-133. The negotiated sentence as outlined in State's 1AS is count 1, 15 years on probation, and count 30, sentencing withheld until the completion of the initial trial of this case. After the initial trial of this case, provided defendant has complied with the special conditions outlined in Section B as in boy, C as in Charlie, D as in Delta, F as in Frank, I as in Indigo of Section 3 special conditions of sentence of this plea agreement, the state agrees that defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. The special conditions of the sentence, as outlined in Section 3, are that defendant shall abide in full by each and all of the terms of this negotiated agreement. Defendant's failure to abide by any term of this agreement shall constitute a violation of the agreement. Defendant shall testify truthfully about all matters relating to this case upon which he is questioned at any trial or judicial proceeding stemming from the facts alleged in this indictment. In accordance with testifying truthfully about all matters relating to this case, defendant acknowledges that each and all of the statements contained within the defendant's factual acknowledgments section of this agreement are true. Defendant shall testify truthfully about each statement contained within defendant's factual acknowledgments and any matters related to this case when asked to do so in any proceeding related to the facts alleged in this indictment. Defendant shall possess no guns unless his right to do so is restored. Defendant shall commit no criminal acts. Defendant shall submit to random drug screenings by the Department of Community Supervision and any agency designated by the court in this case. Should the defendant test positive for any Schedule 1, 2, or 3 drug, defendant shall within 30 days of said positive test undergo drug rehabilitation as designated by the court or the Department of Community Supervision and shall successfully complete said rehabilitation program. Defendant relinquishes any Fifth Amendment right related to any statement contained within defendant's factual acknowledgments contained within this plea agreement. Section 4, defendant's factual acknowledgments. Have you initialed each and all of the defendant's factual acknowledgments contained within section 4 of this document?
Yes, ma'am.
And is that initial AS your initial?
Yes, ma'am.
The factual acknowledgments are as follows. Number 1, Young Slime Life, aka YSL, is an organization made up of 3 or more members or associates who share common identifiers that include, but are not limited to, colors, hand signals, and terminology, who have committed crimes intended to increase the notoriety, street credibility, and reputation of YSL. Number 2, defendant has been a member and or associate of YSL since 2012. Number 3, while associated with YSL and to support and express loyalty to YSL, defendant and co-defendant Demikion Garlington and Quindarius Zachary appeared in a video with another person, AS, where defendant brandished a weapon used in a drive-by shooting, and where on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member, who had begun a relationship with defendant's ex-girlfriend. Number 4, on or about April 28, 2015, as reflected in Fulton County Indictment 15SC 138994, defendant and fellow YSL associates Demikion Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video referenced in Part 3 of this section, targeting family members of a rival gang. Number 5, defendant and his fellow YSL associates committed the drive-by shooting referenced in sections 3 and 4 above on behalf of YSL and to increase the notoriety, reputation, and fear of YSL. Number 6, defendant admitted committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, for his participation in the drive-by shooting referenced in sections 3, 4, and 5 above. Number 7, defendant was told by another YSL associate that immediately after the murder of Donovan Thomas Jr., YSL associates met at the McDonald's on Cleveland Avenue in Atlanta, Georgia, to discuss the murder. Number 8, defendant personally knows that one or more YSL associates committed the murder of Donovan Thomas Jr. on behalf of YSL. Number 9, on January the 10th, 2015, after the murder of Donovan Thomas Jr., defendant and other YSL associates gathered at the home of Jeffrey Williams, aka Young Thug, who gave defendant and other YSL associates cash money to lay low. Number 10, defendant has personal knowledge that on January 10, 2015, after the murder of Donovan Thomas Jr., YSL associates traveled to Miami, Florida with co-defendant and YSL founder Jeffrey Williams, aka Young Thug. Number 11, defendant did not murder Donovan Thomas Jr. and was not a party to the crime. Number 12, defendant did not murder Shamel Drinks and was not a party to the crime. Number 13, defendant cannot truthfully assert that the persons charged in this indictment with the murder of Donovan Thomas Jr. are not guilty of the murder, and defendant will make no attempt at trial, prior to trial, or after trial to exonerate the persons charged in this indictment with the murder of Donovan Thomas Jr. Number 14, the gas station at 151 Cleveland Avenue, Atlanta, Georgia, is one of multiple locations where YSL associates sell drugs and do not allow other gangs to operate. Number 15, the gas station at 221 Cleveland Avenue, Atlanta, Georgia, is another location where YSL associates sell drugs and do not permit other gangs to operate. Number 16, defendant has personal knowledge that he and other members or associates of YSL have either participated in or directly committed at least one of the following crimes in order to increase the notoriety and reputation of YSL: murder, armed robbery, aggravated assault, attempted murder, theft, illegal gun possession, and illegal drug possession and sales. Mr. Sledge, have you had an opportunity to go over each one of the defendant's factual acknowledgments and make corrections where necessary?
Yes.
And do you now acknowledge under oath that each of the factual acknowledgments that you have initialed in this section are true and correct and accurate to the best of your ability?
Yes, ma'am.
Part 5 of this plea agreement, Your Honor, states that defendant's sentencing acknowledgments are as follows. Defendant understands fully that if he violates any provision or any special condition of this plea agreement, the district attorney can and will use the contents of this document and agreement during any judicial proceeding. Defendant understands fully that if he violates any provision or any special condition of this plea agreement, his probation for this sentence may be revoked in its entirety, and the district attorney will recommend that defendant serve any remaining portion of this sentence in confinement at the Georgia Department of Corrections or prison. Number 3, defendant understands fully that any violation of any provision or of any special condition of this plea agreement shall result in defendant being sentenced on count 30 of this indictment, and the district attorney will recommend that the defendant serve the maximum sentence allowed by law. Number 4, defendant understands fully that if prior to the conclusion of the initial trial of this case, defendant fails or refuses to testify to any fact that he acknowledges in this plea agreement, such failure or refusal nullifies any promise made by the district attorney to null pros count 30 of this indictment. Number 5, defendant understands fully that defendant's violation of any provision or of any special condition of this plea agreement prior to the conclusion of the initial trial of this case shall nullify any promise made by the district attorney to null pros count 30 of this indictment and may result in defendant being, and Your Honor, there is a typo that is in this document. It's the word should be being, and it's spelled B-E-G-I-N. I'm going to ask that defendant just strike through and initial that word, B-E-G-I-N to B-E-I-N-G.
Through. Change it to E. And then initial right there.
And Mr. Sledge, is that your initial above the strike through of the word began to change it to being?
Yes, ma'am.
Okay. And may result in defendant being sentenced to serve as much as 35 years of confinement in the Georgia Department of Corrections or prison. Number 6, defendant understands fully that no promises, agreements, or conditions have been made other than those set forth in this document. Mr. Sledge, are these your initials on each section under defendant's sentencing acknowledgments?
Yes, ma'am.
Mr. Sledge, do you agree that the following statement is one that you have read, fully understood, and signed your name acknowledging? I, Antonio Sledge, have read and carefully reviewed this agreement. I have reviewed and corrected where necessary for accuracy each statement contained in defendant's factual acknowledgments, and I acknowledge the truth and accuracy of each and every statement listed therein. I fully understand this agreement, and I've had an opportunity to discuss this agreement and each of its provisions with my attorney, Mr. Derek Wright. No promises other than those contained in this document have been made to me in furtherance of this agreement. I freely, knowingly, and voluntarily enter into this agreement without force, threat, or coercion. Is that the statement that you acknowledged in this agreement?
Yeah, ma'am.
And is that the statement to which you signed your name underneath?
Yes, ma'am.
Your Honor, the state tenders as evidence State's Exhibit 1AS.
No.
Any objection? States 1AS is admitted for purposes of plea.
Mr. Sledge, how do you plead to count to the charge of conspiracy to violate the Racketeer Influence and Corrupt Organizations Act as alleged in count 1 of indictment 22SC 183572?
Guilty.
And how do you plead to count 30 of this indictment 22SC 183572, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yeah, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file what is known as a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Your Honor, the state will now provide a factual basis for this plea.
All right, go ahead, ma'am, whenever you're
Your
ready.
Honor, if this case were to go to trial, the state believes that the evidence will prove beyond a reasonable doubt against this defendant that the defendant, together with indicted and unindicted co-conspirators in Fulton County, on or between January the 24th, 2013 and May 8th of 2022, did unlawfully conspire to acquire, maintain directly and indirectly an interest in and control of United States money and other personal property through a pattern of racketeering activity. Furthermore, defendant did unlawfully conspire to conduct and participate in directly and indirectly such enterprise through a pattern of racketeering activity. The enterprise, Your Honor, as described in this indictment and as the state expects the evidence will show, is called Young Slime Life, also known as YSL. And during the time listed in the indictment, the defendant, along with others, conspired to associate together and with others for the common purpose of illegally obtaining money and property through a pattern of racketeering activity and conducting and participating in this enterprise through a pattern of racketeering activity. The objectives of the conspiracy included, but were not limited to, protecting, preserving, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, including murder, assault, and threats of violence, preserving, protecting, and enhancing the reputation, power, and territory of the enterprise by the posting of messages, images, videos, and songs demonstrating allegiance to the enterprise and a willingness to engage in violence on its behalf, obtaining money, weapons, and other property through acts of racketeering activity, including robbery, theft, and the unlawful sale and distribution of drugs. Your Honor, YSL is an enterprise consisting of a group of individuals associated in fact. It constitutes an ongoing organization whose associates function as a continuing unit for the common purpose of achieving its objectives. YSL is a criminal street gang that started in late 2012 in the Cleveland Avenue of Atlanta, Georgia. Their identifiers vary, and they use common identifiers including colors, clothing, tattoos, and hand signs, as well as verbal and written identifiers, Your Honor. Your Honor, in furtherance of the conspiracy and to effect its objects and purposes, this defendant committed overt acts which reflect his tacit agreement to participate in the enterprise through a pattern of racketeering activity. Those overt acts include but are not limited to the defendant's possession of cocaine with the intent to distribute as alleged in Act 8 of Count 1 on November the 29th of 2013. The defendant's commission of the aggravated assault as listed in defendant's factual acknowledgement on April the 28th of 2015. The defendant's commission of Act 45 in count 1 on April the 28th of 2015, possession of a firearm by a convicted felon. The defendant's commission of Act 46, as alleged in count 1 of the indictment on April the 28th of 2015, of participation in criminal street gang activity. The defendant's posing while an associate of YSL for a photo released on social media wearing pants with the letters OTS, standing for Only the Slime, with the caption of OGs with the green snake emoji and green heart emoji on April the 8th of 2021, as alleged in Act 128 of count 1 of this indictment. And Act 151 of count 1 on December 5th, 2021, as alleged in count 1 of this indictment, wherein defendant possessed a firearm while previously convicted of a felony involving the use or the possession of a firearm. Your Honor, as the defendant acknowledged in State's Exhibit 1AS, defendant has been associated with YSL since 2012 and has committed the acts that are contained in this plea agreement as well, which also reflect defendant's tacit agreement to participate in this enterprise through a pattern of racketeering activity. Your Honor, the defendant, as I stated earlier, has pled guilty to the commission of acts along with other YSL associates in furtherance of the gang YSL. Specifically, Your Honor, beginning back in January of 2015, after the murder of Donovan Thomas Jr. in Fulton County, a series of retaliatory shootings between YSL and the organization of which Mr. Thomas was a member began to occur. One of the retaliatory shootings is the one that is listed in defendant's factual acknowledgments in State's Exhibit 1AS. Your Honor, as recently as this year, earlier this year, the murder of yet another person whom the organization considered a rival, Mr. Shamel Drinks, took place, turning 2022 into sort of a repeat of 2015. Your Honor, the defendant has knowingly, voluntarily, and willingly signed this plea agreement, and as a result of the defendant's willingness to be forthcoming and to be truthful and to own responsibility for his actions, the state is willing to make the recommendation that I've relayed to the court, and we ask that the court accept this negotiated plea agreement. Your Honor, that is all that the state has. If the court will permit me 1 moment, please.
Okay.
That is all that I have, Judge. Again, we would just ask that the court sentence the defendant to 15 years of probation on count 1. As to count 2, we would ask that the court withhold sentencing until after the completion of the initial trial of this case, and that after the initial trial of this case, provided that the defendant has complied with the special conditions outlined and contained in the plea agreement, Your Honor, the state agrees that the defendant should be allowed to withdraw that guilty plea on count 30, and the state shall agree and will agree to no loss on count 30. Your Honor, further,
Mr. Wright is well. He's Mr. Sledger in the sentence already. Is this going to release him?
Your Honor, that closed out once you did the time.
Yeah, yeah.
Judge, the case that was referenced that he pled guilty to before for the ag assault is closed. So he's not currently under an active sentence.
The issue is gonna be is that he's got no sentence under that particular count 30. So I'm not gonna have to give him bond. I mean, I
made bond
the
already.
sentencing on count 30. He won't be able to release it.
Initially, when he was arrested for count 30, he was given a $31,000 bond that he made. So
So that bond still remains in.
that bond is still in effect for that, I guess, underlying charge.
As of right now,
But
in this case, there's no bond set. We don't know if that was the previous indictment, but as of this case, 22 SC 183572, possession of a firearm by a convicted felon, no longer.
Your Honor, if I may.
Judge,
Sir,
Mr. Harvey, Mr. Nichols will be removed so he can have a restroom break and he'll be brought right back.
All right, cool. Thank you.
You're welcome.
Did you hear that?
Yes, that's not a problem, but it's the officer that's working the tower. He wants
Tell him not to worry about that. Tell him not to worry about that.
Yeah, relax.
Just relax, please.
We got it.
Captain Dooley, I got it. I'll call the floor.
All right.
And so
How? Because he's sitting on a chair. So how is it different, a wooden chair, padded chair?
I think from my understanding, he needs a padded chair. And they just have those fold out metal chairs. And I don't know, I've never had a rod in my leg. I don't know if the metal on metal affects it or if it's just a weight issue. But that's my understanding.
Okay. Okay, well, he's the only other person that we're trying to account for. So, I'm just trying to make a decision as to whether or not, because he's the only person that, if he's not willing to waive his waive his presence, then I'm going to probably have to put a pin in these proceedings today.
I understand, Your Honor.
No, I don't know if you do really, but that's okay.
I will also, okay. I understand, Your Honor.
Your Honor, Mr. Farley is in the same.
I'm sorry.
Mr.
No.
Farley as well. I don't believe is.
Well, Mr. Yes, Mr. Menez.
Yes, Your Honor. Good morning.
Were you going to say something, sir? I'm sorry.
Oh, no, Judge. I just heard Mr. Farley's name, so I turned my video on.
Mr. Farley's on the platform, I think, though. Yeah, so. Okay, all right. Okay, well, what I'm going to do now is, who's that? I got there. Mr. Menez, could you go ahead and mute yourself, please?
Yes, Judge.
Thank you. Mr. Sharp,
I'm sorry, there was an echo.
Yeah, I got it. You're good. You're good. Okay, all right. So we'll just talk administrative at this point in time. Council, it doesn't look like it's, that we're going to be able to at least do any more business today. Given the fact that I can account for everyone except for Mr. Stillwell, who doesn't seem to want to waive his presence. That's his right. He probably doesn't want to waive his presence either. But here's what I'm going to do. I think with some of these things, like with Mr. Farley's evidentiary motions, that are still,
I can't hear them.
can you hear me now?
Yes.
Okay, all right, good. Okay, Mr. Menendez, I'm just going to go ahead and table your particular motions for the time being. I can always hear them prior to the witnesses being called, so I'm going to just defer them for a little while because we're kind of running out of time. So don't have to deal with those today, sir. So that will resolve the issue of your client not being there, okay?
Understood, Your Honor. Thank you.
All right, good. Okay, all right. As for Ms. Viverito, folks, she's on the platform. She was the person we were supposed to do today. Is that correct, Ms. Rosenwasser?
That is one of the people, Your Honor.
Yes.
All right, and I should say Ms. Love. Okay, all right. Okay, so who else do we have left? We have Mr. McKinney, Mr. Dunbar, and Ms. Stanley. Is that right?
Your Honor, we have Mr. Voss waiting outside today. He's another ballistics expert. He's ready and waiting in the witness room. We also have tomorrow, McKinney still going? Dr. Stanley Sims and Mr. McKinney. And my understanding is that Mr. Steele has 6 experts that he wished to qualify tomorrow. And then we also have Mr. Steele's evidentiary motion to suppress statement, which had been scheduled for this afternoon. So That's what we have left. But our witnesses, we certainly can do at the court's pleasure, either now or before their testimony at trial.
Judge, we have evidentiary motions as well.
Yes, Your Honor. Mr. Harvey does have those. We just filed our response. I don't believe they've been set for a date, so we would need a date to get our witnesses here for those. But we would have no objection to do those during the trial or before the issues come up at trial.
Yeah, I think the issue that's coming up now is we're running out of time, or time's kind of not on our side in terms of being able to conduct other business. So I may just I think I've dealt with all of the necessary motions that I have to have in order for the trial to go forward. I'll have to deal with the rest of these before the issues comes up in trial, or before that witness is supposed to testify.
Your Honor, if I may.
Yes, you are.
This is Max Shard on behalf of Mr. Stillwell.
All right.
I just wanted to bring it to the court's attention, and I believe that Mr. Harvey is similarly situated. While I appreciate Your Honor saying that we can deal with some of these things once trial starts, we do have an outstanding motion to sever charges that I believe is a strong motion regarding one of the counts, one against Mr. Stillwell, one against Mr. Nichols, that would affect the indictment itself.
I thought we did those already. I thought I don't believe those already.
No, Judge, not as to Mr. Nichols, and as to the firearm count, that's the last count in the indictment.
Your Honor, I believe Mr. Shart at least filed his motions last week, so they were filed fairly late, untimely, which is why we were not able to respond to them, and they weren't done. They were not done within the court scheduling order requiring motions to be filed by the first.
Your Honor, I'm still getting discovery on that case, but that is a non-evidentiary motion. That is just a legal motion, and I just wanted to bring it to the court's attention because obviously we would need to sort that out before we start the proceedings.
All right. Well, Ms. Rosenwasser, can we deal with that tomorrow?
Deal with the emotions or the issue itself?
I don't know. Clear. Your Honor, which specific issues does the court want me to deal with tomorrow?
Mr. Shart and Mr. Harvey's motions to sever.
To sever the firearms counts that are at the end of the indictment.
I don't know how many seconds. I can try.
I didn't file it late.
Yes, he did not file.
Thank you, Mr. Harvey, because that's that.
Your Honor, we can deal with Mr. Nichols tomorrow, but because Mr. Stillwell filed late, we haven't had a chance to respond. So we asked that if you're going to have the ability to respond to it, we haven't had time. I believe the email was sent last Thursday, so the 26th.
And Your Honor, I'm not trying to be difficult, and that's fine. It's the exact same issue. We are exactly similarly situated to Mr. Harvey. It's the exact same legal issue. It's just a matter of can charges from separate incidents be joined in the same indictment?
We will make an effort to be ready whenever the court elects.
We got to resolve that issue because I had planned on at least tomorrow to discuss the people that need to be severed before next week. So it's probably timely. We probably need to take care of that so I can at least kind of figure out.
That's fine. We'll be ready for this.
Yeah, so let's do those tomorrow morning. If worse comes to worse, I mean, because they don't really, they're legal motions, so we should be able to deal with those. Yes, Ms. Bernard.
I had joined in a motion to dismiss that and double jeopardy, and I added my double jeopardy claim on behalf of Mr. Myrick. But it was a motion that they asked and attorney King, I'm sorry, had filed. I'm not aware of the court's ruling. I didn't see an order, and I don't know whether a ruling.
Okay, I'm gonna deny that motion. Ms. Rosenwasser, if you would go ahead and please do an order. If it's the same, you have anything extra you want?
What I added, as it relates to Mr. Myrick, Judge, he's already pled and been indicted, pled and done time under sentence on acts in the indictment for count 36 and 37, which is an armed robbery and aggravated assault from 2015. My client is under sentence. He pled guilty in 2016. And he is being, additionally, in this indictment, he has to defend himself against that for the RICO count, and he's already handled that. That's double jeopardy under 16, I think it's 7-1, I'm sorry.
Madam.
We've already addressed that in numerous other motions.
We have. Ms.
The court's already issued orders.
Yeah, no, but, no. Ms. Bernard, you're absolutely right. And for those same reasons I've already stated earlier, I'm going to deny the motion, okay? But, okay, all right? Okay, folks, in terms of other... All right, folks, here's what I'm going to do. I think the first thing tomorrow is to do the motions to sever. Now I know you have Ms. Viverito still. You got Mr. Voss. You got Mr. McKinley, Mr. Dunbar, Ms. Sim Stanley. My fear, folks, is that like I said, we're running out of time in terms of the ability for the court to hear these and rule on these. We may just have to take them up as they're presented during trial. So, any other issues, folks, in terms of that? I mean, I'd like to be able to accommodate you, but I don't have any time next week. We're supposed to begin jury selection 5, 6, 7. So, 4, 5, 6, I should say. Thank you. And the other thing I'm kind of battling against is folks that are still kind of under the weather. And so if I can get everybody here tomorrow, we may be able to take up some of these other folks. But in the absence of that, we're going to have to kind of just wait until till we have some time before that witness is called.
Your Honor?
Yes, Mr. Williams.
My client, Mr. Ryan, would like to have his Feretta hearing.
We may be able to do that today.
Yes, Your Honor.
Okay? All right. Okay. Any other administrator that I need to, that anybody else wish to be heard on?
Yes, Your Honor.
Yes, Mr. Menendez.
Your Honor, I would just want to know the mechanism for seeing the test results of Mr. Farley's for the reason why we were on video today. That's all. I just need some guidance from the court about that.
He's tested positive. I understand that because of that, that's why he was not brought over. Okay? So, have you been tested, sir?
No, Your Honor, I haven't. I guess I'll follow up with the court staff about that, what the protocol is for me to be allowed physically.
At the table with the rest of the folks that were, that tested positive, I would think that you'd want to go ahead and at least see if, just to satisfy yourself, you're sitting right next to Mr. Sharp and Mr. Botts.
Yes, Your Honor.
I mean, that's be responsible for the rest of us here. But I can't force you to do that. But I would certainly think that might be prudent.
Yes, Your Honor, that's right.
To satisfy yourself. All right, but yes, that's why your client was not brought over, and he probably will not be brought over tomorrow because the jail is, I should say, protocol is usually they're isolated for 5 days. So that's why I'm making him available.
Okay.
That answer your question? I mean, and tomorrow would just be for any other ancillary proceedings that we might have. But in the absence of that, then I certainly will probably have to wait until later to finish your motions.
Yes, Your Honor, that's no problem at all. I just wanted to inspect or verify those test results as his attorney.
You don't think that do you think that the jail is not being candid with you?
It's a possibility, Your Honor, but
you are welcome to file whatever motion you need to, or take that up with the jail.
Understood, Your Honor.
As you see fit, sir. Okay.
Yes, of course.
All right. Anybody else? Yes, Mr. Matthews.
Yes, Your Honor. I would abundance of caution. Mr. Huey, it's my understanding, is either a cellmate or roommate with Farley. And I'm concerned, just out of protocol, that maybe the jail can take some type of accommodations to make sure that Mr. Huey, who has tested negative up to this point, remains in that position and doesn't get exposed to his roommate who has tested positive. Those are my concerns. Maybe
Okay.
the jail will take some steps. We're sitting there back. I've got to sit next to him. I don't want him to get sick. I don't want to get it. I don't want to hand it off to a skinny colleague who's sitting.
I'll talk to Captain Julie. Okay. All right. Anybody else?
Yes, Your Honor.
Yes.
Your Honor, Mrs. Williams has two additional motions, Your Honor, a motion to suppress that I thought we were going to hear today. However, I didn't know what the court's positioning is on those two. They are evidentiary motions. They are motions suppressed that could be heard. Sure, they are evidentiary motions that could be heard prior to trial, but just wanted the court to be aware of those two outstanding motions as well.
I think the problem is that Ms. Hilton, is that even though that those are only related to Mr. Williams, since you got a RICO count, everyone else has opted in and wants to be present for all motions. So that's the issue that's going to come up.
Thank you, Your Honor. We just had two witnesses here, so we wanted to know we would be able to release them.
So that's the problem with that. Mr. Steele?
Good afternoon, Your Honor.
Good afternoon.
Leave this on, I guess. Can I just make sure that I'm correct that Dr. Dunbar is flying from the state of Nevada, but tomorrow he has plane reservations and can come? Should I have him come, Your Honor, or is that something that I shouldn't do?
As you can see, I mean, it's kind of like it's going to depend. It's much going to depend upon whether or not your colleagues wish to waive their client's presence, or they'll be available via Zoom. I think waiving is not really the issue, because that's most people don't. I wouldn't, from a constitutional basis, I don't think that that's something they probably would do. But for the folks who are COVID positive, those folks I will probably still take at the jail. Are we going to be able to finish him in a day? That's the thing is.
Where would the court? I just don't want him to fly here and then, not get taken. I could cancel him and we could do it at another date certain. It's no problem. I just wanted the court to, whatever's convenient for the court, and we will do it.
Oh, it's not a question of convenience, Mr. Steele. I think this is a question of availability for and the fact that we are kind of battling two fronts. One of them is just time, and the other one is people that are just unfortunately becoming sick or whatever else. So. I mean, I can check with the folks that are on the platform who are going to probably be. Mr. Menendez?
Yes, Your Honor, I'm here.
All right, Mr. Farley's probably going to be on. He's going to be via Zoom tomorrow, because he's still going to be under a COVID protocol.
Yes, Your Honor, we don't have any, we would waive our physical presence. I need to speak with Mr. Farley, but my guess is that we would waive our physical presence for the motions that don't involve him. For example, Mr. Steele's motions and anything else. We would reserve, though, our right to have everyone in person for those motions to suppress of ours that we already discussed.
Sure. Okay. All right. Ms. Bernard? For Mr. Myrick, I think, would you be willing to waive his physical presence and he could appear via Zoom tomorrow?
Considering his current status, as what we discussed, he will be present by Zoom.
Okay, that's two. And who else do we have? Mr. Harvey?
Good afternoon, Judge. I think Mr. Nichols would make the exact same announcement that we were going to make for today, so we will be available by Zoom if he's feeling okay and up to it, and he seems to be. So we'll be here tomorrow.
Okay. All right.
Is that right, Mr. Nichols?
Okay.
Your Honor, if I could briefly address Mr. Steele's position. The only person that he really wanted to be over here for is Mr. Polito. Anything else he'll waive his presence today. Other things he wants. It's only for that he was requesting that he come over on 16 days, which he was the supervisor. And so I thought we made something that come up on this.
Okay, I'm sorry, Judge, I didn't understand any of that. It's hard to understand on the platform here.
Can you go to a microphone, Mr. Botts?
Make it clear to the court, Mr. Stillwell will waive his presence for anybody but Ms. Viverito, which she was scheduled to start today for cross. But yes, other than her, you can proceed with any other witnesses you want to or any other hearings today, right now. And I hate to bring that up, but that's our position.
Okay, all right.
So
thank you, Mr. Botts. I appreciate that.
Yes.
All right. Anybody else? So councils, this is from a scheduling standpoint. Do you want to go ahead and see? Mr. Steele, do you have any other witnesses or any other experts you're going to try and qualify? Mr. Dunbar is, or Dr. Dunbar is coming from Colorado?
The state of Nevada.
Nevada?
We have Jim Persinger. He's local. I have to call him, but he maybe can come tomorrow if the court thinks that's appropriate in time. And then we have Dr. Eric Nielsen. He's in the state of New York, I believe. I'd have to call him and see if he could come here tomorrow. We have another professor from California. I have to speak with her to determine whether she can make it here tomorrow. I don't have those reservations done, Your Honor.
What type of a doctor is Dr. Dunbar?
He goes to the motion that's outstanding about using hip-hop or rap lyrics in this trial against Mr. Williams under both the Constitution as well as the statute, freedom of speech, as well as a 24-4-403 analysis. And he's done studies on the topic. I've given all of his work to this honorable court and the prosecution, as well as his CV.
Okay.
And that's why before that motion or during that motion, I wanted him to testify. So if we're arguing that motion, that's really what he is for. He's really not a trial witness. He was just for that motion.
Okay. All right, State. What's your thoughts about doing Mr. Dunbar tomorrow, Dr. Dunbar tomorrow?
Your Honor, we can be ready to handle Dr. Dunbar tomorrow. We also have two of our witnesses scheduled for tomorrow. Dr. Stanley Sims, Melissa Stanley Sims, who's available tomorrow morning, and
She's a medical examiner?
yes, Your Honor.
All right, she won't take that long. Okay, who else?
And potentially Mr. McKinney. But, Your Honor, Mr. McKinney, due to medical needs, would need to be via Zoom. So if the court's amenable to that, just with all the medical things that have been happening, that would be our only issue with him. But he's available via Zoom tomorrow.
Does he has he tested positive for COVID or something?
No, Your Honor. There's other.
Okay. Yes.
Your Honor, we do have Mr. Voss here today. If the court would like to hear from him today, he's available and he's here. He's a ballistics.
Yeah, we can do Mr. Voss, it looks like, so we could probably take care of him today.
And Your Honor, our question is, we had planned for all of Mr. Steele's experts tomorrow as well, and we just want to know whether we should plan to go ahead with them or not to go ahead with everyone except Dr. Dunbar. We just want to know, we want to make sure that we're ready for the court.
Well, it's up to Mr. Steele. Had you planned on calling all your witnesses tomorrow, Mr. Steele?
No, but I can make a phone call and see if they can get here, if that's better.
Your Honor, that is what we had planned for Mr. Steele's. I believe that was the request that he had made of the court, that he be allowed to present his witnesses. Forgive me, Mr. Steele, if I'm misstating something that you had previously said. So that is what we were expecting for tomorrow, but if that is not something to which the court is amenable, then we'd just like to like to know at what time the court or what day the court will be hearing those witnesses, and certainly we have no objection to the court's accommodation of any restrictions.
Mr. Steele, I don't have any. I think that he should definitely. We'll hear from Dr. Dunbar. I think that the other issue related to that was your colleague, Mr. Adams, indicated that there may be some questions from voir dire that may be relative to that particular issue. So that might be the reason why we need to take it up. So to the extent that we can do your witnesses, Mr. Steele, as well as Mr. McKinney.
Dr. Sim Stanley, Your Honor.
Dr. who?
Dr. Sim Stanley, Melissa Sim Stanley.
Yeah. Well, can you get her this afternoon by chance?
I don't believe she's available this afternoon, but we can certainly make a call and see. I do not believe she's available until tomorrow.
And Your Honor, if the court will permit the state an opportunity in the form of about 2 minutes or 3 to speak with Mr. Steele regarding his witnesses, or Mr. Adams regarding their witnesses, we would appreciate that opportunity.
Sure. I can recess in place.
Thank you, Judge.
All right.
Mr. Steele and Mr. Adams.
What did I say?
That would.
I'd ask, just for clarification purposes, and so we'd ask that that happen in the afternoon. I know that after speaking with Mr. Steele and Mr. Adams, the court, they indicated that the court had reserved their ability to ask at least one of the requested questions during the voir dire process until after the court heard from this particular tendered expert. So it's my understanding, and I'd ask for clarity, that we are simply going to have the Daubert hearing on Dr. Dunbar. We'd ask that the motions portion be held after we begin or have chosen or started the jury selection process.
Mr. Steele?
Okay. So we filed a motion to exclude, lyrics based upon freedom of speech and constitutional setting, as well as a statutory basis under 24-4-403. That's what Dr. Dunbar is coming to try to be qualified as an expert in, and then, if qualified, educate this honorable court from a perspective from his research. So we would like to argue the state's motion to introduce lyrics, and we would like to argue our motion to exclude or remove those lyrics from the case. And then, depending upon your ruling, that would, your honorable court could then possibly hear from us about the two, I believe, voir dire questionnaire matters or questions that Mr. Adams has targeted. So we would like to do the motion tomorrow.
Are we having a Daubert hearing as to Dr. Dunbar tomorrow?
I was going to do both because we were going to qualify him as an expert for purposes of that motion. So I was just being courteous to tell everyone that. He's not going to be a trial expert, though. We have no intent to call him a trial at this point.
But he is being tendered as an expert for some purpose with respect to this case. So we do have to have the Daubert hearing. Am I correct? So, Your Honor, my concern is that that portion may be more protracted. We have some witnesses. I do believe that that may be an extensive hearing, and that is the reason that we are asking to have the testimony, or the hearing rather, not the testimony, but the hearing on Dunbar tomorrow, and the motion on the lyrics later, because I believe that this may be a protracted Daubert hearing. And we also ask that the court allow us to do it in the afternoon because we have other witnesses and motions. Specifically, I believe the court mentioned the motion to sever counts that we need to take up before next week.
Well, yeah, the motion to sever the counts definitely has to be taken up. And I think that we're also going to take up Dr. Sim Stanley.
Correct, Your Honor.
Ms. Love and Mr. Steele?
Your Honor, we were just discussing what we just spoke with the court about, the fact that the Daubert hearing itself is likely a more protracted process, and we would ask that the court allow us to only have the Daubert hearing as to Dunbar tomorrow and have it in the afternoon. Let us have the motions that are still outstanding that have to be done prior to the beginning of trial, along with the witnesses that we had discussed with the court in the morning, and have the lyrics motion later on.
Okay, Mr. Steele, you okay with that?
We're with the court. We'd like to do it at one time, obviously. The gentleman's flying across the country, but we'll just leave it with the court. We'll do it whatever way the court thinks best.
We'll just try and use our time as wisely as we can on that one. So we'll plan on just doing the Daubert for the time being, and then we can do the other one a little bit closer to him testifying, okay?
Yes, sir.
Okay, all right. Anything else?
Yes, Your Honor, and thank you. That sounds great to the state as well. And to be clear, my understanding was that he would be, as far as his testimony is concerned, that will rely solely on the court's decision after or during the Daubert hearing itself. So that's another reason that we has to have that hearing first.
Okay, all right. Okay, yes, Ms. Rosenwasser, anything?
Your Honor, we were just curious if we could have Investigator Riverito excused.
Yes.
And also if we could have witnesses that we had originally planned to call, had Mr. Steele's motion suppressed, gone forward this afternoon excused as well, so that we can have those.
Yes. Is Ms. Riverito on the platform? She is.
I am, Your Honor.
Ms. Riverito, I'm going to go ahead and or I should say temporarily excuse you for the time being. Just don't discuss your testimony to anybody except the attorneys in this case, and we'll call you when we need you to begin your cross-examination, okay?
Yes, Your Honor.
Okay, thank you, madam.
Thank you.
Okay, all right.
Go on, Mr. Voss.
Okay, all right, let's summon Mr. Voss, please.
Your Honor, if I can make a brief.
You can.
Due to the prosecution's refusal of Ms. Riverito, we will not need to have Mr. Stillwell brought over. So.
Tomorrow?
Yes.
Can he, do you want him available via Zoom?
Yes, if he can get a cushion, if the jail can accommodate him there where he can sit. If he does not want to do Zoom, then fine, but I would like for him to do it. And even though it's just testimony that doesn't concern us, but still, he needs a cushion. That's the only request because of the leg issue. And it's a very cramped place where he's in. That's the only thing.
Hold on. Let me just send a message right now.
Okay.
Do you have it? I think he's scheduled to come over anyways.
Do what now?
He's scheduled to come over to the courthouse because he's tested negative. So, I mean, I can still have him brought over.
If that's the court's desire.
Well, for other reasons, yeah. Let me just kind of find out, but I think we'll probably just bring him over tomorrow. Okay.
Okay.
Okay. All right. Okay, Mr. Voss, good afternoon, sir.
Good afternoon.
Sir, if you'd be so kind to turn and face Deputy Talton before you sit down and to be sworn as a witness, please.
Raise your right hand. You swear to affirm the testimony to give the court the truth, the whole truth, and nothing but the truth, and nothing.
I do.
You want to take your seat?
David Voss, David common spelling, Voss, V-O-S-S.
Okay. And good afternoon, Mr. Voss.
Good afternoon.
Are you currently employed?
Not by the GBI, I'm retired right now.
Okay. Now, you said you're retired. Where are you retired from?
From the Georgia Bureau of Investigation.
Okay. And how long were you at the Georgia Bureau of Investigation before you retired?
Over 19 years, less than 20 years.
Now, before you went to the Georgia Bureau of Investigation, did you get any education, college, or any other programs?
Yes.
Where did you get those education?
I have 2 bachelor's degree in engineering from Iowa State University, a master's degree in engineering from Pennsylvania State University.
Okay. Now, what were the jobs that you did at the GBI?
I started off in the radio room as a technician or as a radio operator. From there I went to the forensic side and became a firearms technician. Then I took training and became a firearms examiner. And then I went into evidence receiving.
Okay. Now, in 2015, March 2015, where would you have been a firearms examiner at that time?
Yes.
Okay. So I want to focus specifically on that job that you had. How long were you a firearms examiner at the GBI?
From 2009 to 2015.
Okay. And what kind of training did you have to get to have that job?
I was trained as a firearms technician in the handling of firearms, safe practices, firearm repair, stuff like that. And then to become a firearms examiner, I was trained, it was a 2.5-year training program. It was administered by a firearms scientist and who eventually left the GBI. So the firearms manager, George Stanley, then became my trainer.
And how long were you in training total to become?
2.5 years, I believe.
Okay. Were there other training programs that you attended?
Yeah, there's armor courses I attended, and then there's also professional training that was through the, if I may look at my notes, like a tool mark training.
Okay. And when you said armor training, what is armor training?
Gun manufacturers would send out representatives of their company that would train us like how to disassemble and reassemble firearms.
And did you ever receive any certifications as the result of your training? In armor or
Yes, yeah, you receive an armor certification from each of the companies.
Okay. And was that while you were working for the GBI that you received those certifications?
Yes, it was.
Okay. Did you also train with the National Forensic Science and Technology Center?
Yes, that was the tool mark training.
And what is a tool mark training?
Tool mark training is a tool that impresses striations upon an object. So like you take a sheet of copper and you take a screwdriver and you press it against the sheet of copper. You go across the surface of it. You look at the striations that are caused by the tool.
And how does that, is that like something that comes up in firearms analysis a lot? And if so, how?
Yeah, firearms identification is a subset of tool mark training in that a hard surface, it creates striations on a softer metal. And we look at those striations as a pattern.
Does that help you in identifying certain firearms or bullets that have been fired from them?
Yes, it's the philosophy of tool mark training that creates ballistic identification for firearms identification.
Okay. Now, while you were working with the GBI as a firearms examiner and getting all these trainings and certifications, did you ever have to do any continued proficiency tests or anything to ensure that you were doing your job correctly?
Yes, there's yearly proficiency tests in firearms.
Okay, and did you pass your proficiency tests?
Yes.
At the time that you did this report, in this case in 2015, would you have passed your proficiency test that year?
Yes.
Did you ever fail a proficiency test?
No.
Okay. Have you ever testified as an expert witness in this field before?
Yes.
And about how many times have you testified before?
I believe the last time I testified was 2019, and I believe that was number 98.
So is this your 99th time?
Yes.
Okay. And what were those all in Georgia or in other states?
All in Georgia.
And what fields were you qualified as an expert in?
They called it ballistics or firearms identification.
Okay. Now, while you were working at the GBI or in other fields, did you ever provide anyone else with training?
Yes, I was. As a scientist, you are expected to devote some of your time to training newly hired scientists.
And what kind of things did you train the newly hired scientists in?
It would be like safe operation of firearms, collection of bullets and cartridge cases, documentation of results, writing reports, serial number restoration, tool mark examination.
Okay. Your Honor, if I may approach the witness with what's been marked as State's Exhibit 23, and this is Mr. Voss's CV. I have it available if anyone would like to view it.
You may, madam.
Okay. Mr. Voss, if you would please look at this document. Do you recognize this document?
Yes, it's one that I provided.
And what is this document?
My curriculum vitae.
Does there appear to be any substitutions, alterations, deletions, as far as you can tell from what you remember providing?
It appears to be identical.
Okay. Thank you, Your Honor. The State at this point would move to admit State's Exhibit 23 for the purposes of this hearing.
Any objection? Hearing none is admitted.
Now, Mr. Voss, can you please explain the type of testing that you did while you were at the GBI? If you can kind of go into the science behind it and how the tests are conducted, particularly the ballistics comparison testing.
Okay, as evidence come in, for instance, a firearm would come in, we would have to inspect it. If it's have blood on it, we'd have to clean the blood off of it. Then we do a safety examination of the firearm to see if it's safe to fire. If it was deemed safe to fire, we would do 3 test fires into a water tank. We shoot bullets. We would collect the bullets and the cartridge cases, and then we would examine the test fires to see if we could find reproducible striations or markings on the cartridge cases and bullets to prove that the firearm was creating reproducible markings.
Okay, and so if you say microscopic examination, what does that mean within your field and your field of testing?
Well, the striations that were imparted on the bullets and cartridge cases are microscopic in size, so we'd have to look under a microscope to find these patterns of striations.
Okay, and were you trained to do the type of testing you described?
Yes.
Is that the training that we talked about earlier?
Yes.
Okay. As far as you know, is there any error rate to this type of testing or rate of accuracy?
Years ago, through the NFSTC training, they said the error rate was approximately 1%.
Okay. And did you ever have your own work checked by others or an error rate given to you?
Yes, in 2015, all of the reports that each scientist created, the evidence was looked at by another independent scientist, and conclusions had to match, or they had to be resolved if there's any differences.
Okay. Now, as the microscopic examination and comparison, if those tests are done correctly, what might those tests show when you're finished with your testing?
Will it either be a identification that firearms evidence was identified to a firearm, or there'd be elimination where there was no way, or in our opinion, no match between the evidence and the firearm, or there could be an inconclusive result if there was so much damage to the evidence that we couldn't make a conclusion.
Okay. And did the GBI, when you were there, have any rules or standards that controlled how you did your job?
Yes, of course, there's standard operating procedures, yes, the guidelines we have to follow.
And did everyone at the GBI follow those operating procedures?
Yes, it was documented.
Okay. So those procedures were written down, is that fair to say?
Yes, there are, yes.
Okay. And when you did your test, did you always follow those standards or best practices?
Yes, and if there's a instance where I couldn't, I had to get a release of standard practice procedure through the technical leader.
Okay. Now, is this type of testing, does anyone check your work when you do these testings?
There's an independent scientist that does a verification on all the evidence.
Okay, so if you do a report, someone's checked it over before we would see it, is that fair to say?
Yes, and they have to do the same comparisons, and they have to also create a worksheet that states that they are in agreement.
Now, do you know if the GBI was accredited by anyone at the time that you were employed there?
Yes, it was accredited by the ASCLAB lab, the American Society of Crime Lab Directors.
Okay, and I guess, what does that mean as far as you know? Does that mean if they're kind of doing something normal, or I guess, can you explain that?
Yes, they send around inspectors, I believe, on a 3-year basis where they inspect our policies and our routines to make sure that we are following what we say we're going to do.
Okay. So it would be fair to say they do this to other laboratories as well. Is that fair to say?
Yes, I was told they did other laboratories as well. They do a 3-year external audit where they send professional auditors in, and then every year there's an internal audit where we have our own trained auditors to look at our procedures and processes.
Okay. Now, did you examine various firearms and cartridge cases that were sent to you in in case number 2015-1001-545?
Yes.
Okay. And when you did this, did you create a report as a result of your work on this case?
Yes, I did.
Now, to create was that report peer reviewed by anyone before it was submitted? Did someone check your work?
Yeah, yes, it had to be peer reviewed to be released. Yes.
Okay. And when you did this report, did you follow all of those best practices and standards that we talked about?
Yes.
Okay. Your Honor, based on Mr. Voss's years of experience, his background, his training, and the fact that this is a well-established, accepted field of forensic science that this court has actually qualified twice before yesterday, we would ask that this court qualify Mr. Voss as an expert in firearms examination.
Anybody wish to vote Mr. Voss? Okay, hearing no objection, the court will designate Mr. Voss as an expert in the area of firearms examination. Mr. Voss, at this point in time, I'm going to go ahead and temporarily excuse you as a witness. Don't discuss your testimony with anybody except the attorneys in this case. We'll call you when we need you, okay?
Okay, understood.
Thank you, sir.
Thank you.
All right. Okay, folks, any other administrative issues we need to take up? All right, so here's the plan for tomorrow. Plan for tomorrow is we'll do the, when everyone's here, we'll do the motion to sever, involving Mr. Stillwell and involving
Mr. Nichols.
Mr. Nichols, thank you, Mr. Harvey. And then we'll do the medical examiner. We'll take up Dr. Dunbar, and then I'll talk about who I'm going to sever out before we start next week with jury selection on 4, 5, and 6 January. All right, anything else I need to take up, folks?
Mr. Ryan?
I'm gonna do your Feretta hearing as soon as we break. So just give me a minute. I'll take that up in just a second. All right. Anything else? Okay. If not, then the rest of you, other than Mr. Williams' client, I'm going to excuse you all, and we'll see you all tomorrow morning. Then, okay? All right.
Judge, I assume since Mr. Nichols is still under quarantine that I can appear by Zoom tomorrow.
You can, Mr. Harvey, yes.
Okay, thank you.
All right, we'll see you tomorrow, okay?
Yes, sir.
Okay, all right.
Your Honor.
Yes, sir.
Can I just ask a question? Dr. Dunbar in the early afternoon come over here, is that fair to say?
Afternoon.
That's what you said? That's
We're
what
going to have the daughter. That was my understanding.
Okay. I just wanted to know.
All right, okay.
Okay. Thank you.
Obtain employment. Do you understand?
Yes, ma'am.
All right, Christine, you ready? All right. All right, we're on the record in the matter of the state of Georgia versus Antonio Sledge in 22 SC 183572. Good afternoon, Mr. Wright.
Good afternoon, Judge.
Good afternoon, Mr. Sledge.
Good afternoon, Your Honor.
And good afternoon, Councils Love and Hilton. Okay, Councils, I understand this is supposed to be a negotiated plea. Is that correct?
That's correct, Your Honor.
Yes, Judge.
All right. Mr. Sledge, can I get you to raise your right hand as best you're able?
Yes.
Do you solemnly swear or affirm that the evidence you shall give in the matter now in hearing should be the truth, the whole truth, and nothing but the truth, so help you God or so affirm?
Yes, I do.
All right, you put your hand down, sir. All right. Mr. Sledge, over the next several minutes, what's going to happen is we're going to go through such a thing called the providency inquiry. So basically, in our system of jurisprudence, we don't force people to plead guilty. So I have to be assured you understand your constitutional rights and that you freely and voluntarily waive those rights so I can go ahead and sentence you. The second thing it does is we go through a factual basis, and I determine if there's a factual basis that the state would have been able to prove in this case beyond a reasonable doubt had they tried the case. So assuming that I find that you understand your rights, we call it the Boykin inquiry. And then the second thing is then I find that there's a factual basis I can accept your plea. So, Ms. Lace, which one of you is going to do the plea?
I am, Your Honor.
That we have.
If you can.
He decided to classify Mr. Dorsey as sex money murderers because he said, yes, I am. Is that right?
Yes, along with the tattoos or the picture of the tattoos that she took.
Are these interviews recorded?
No.
So it is just what the officer remembers, and we got to take her word for it.
Yes.
Now, let me correct that. Actually, we don't have to take her word for it because she's not here. We have to take your word that she did that. Is that right?
Yes.
All right. Now, you were asked on multiple occasions, what do you do to classify somebody? And if I remember correctly, you kept answering, we look at literature, we search the cells, and we listen to jail calls. Is that right?
Yes.
All right. Now, when you look at literature, specific to Mr. Dorsey, what literature did you find in his possession?
I didn't find any literature in his possession.
I'm sorry?
I didn't find any literature from Mr. Dorsey.
Okay. Now, sometimes there's multiple steps because you want to corroborate, right?
Yes.
I mean, somebody can tell you, I am Billy, but they're really not. They are hypothetical. They might say, I am Billy, but they're not. They might be a gangster disciple, but they want to be placed with the Billies because maybe they have a reason to go in there and take care of something. Is that right?
Yes, that could happen.
People lie to you. Is that right?
Yes.
Okay. So then once you hear something, you go and you look for more information. Is that right?
Yes.
Okay. You didn't find any literature regarding Mr. Dorsey?
No.
Now, what are the identifiers of sex, money, murder?
You might see a tattoo with a SMM. They might have a Portland Trailblazer symbol on them, or a blazer, or they might show 2 guns or have 2 guns, or you might see the word 2 guns.
Okay. And once you have a tattoo, is forever, isn't it?
Yes.
All right. And is gang membership eternal? Are you a gang member forever?
Yes.
Okay. So once you're in one gang, you can't shift gangs.
You can.
You just told me that you're in a gang forever. How are you going to do that?
But it's still considered a gang.
Oh, okay. Okay. Part of your training, am I right, is that they tell you to also consult with other agencies, correct?
Yes.
Because what you're doing is you're gathering intelligence, is that right?
Yes.
And you don't want to have just the intelligence of a small circle of information, right?
Yes.
Okay. What agencies do you consult on a regular basis?
The Cobb County Police Department and Department of Corrections.
All right, but that's still just the same group of people you're dealing with, right?
Yes.
Do you ever go out and consult with the investigators in Troup County?
No, I haven't.
Now, Troup County has a very big gang problem, don't they?
I don't know.
We're not qualifying this.
I sustain the objection.
Okay. So today, you're here to tell us that the only thing you only know stuff at the jail. Right?
Yes.
All right.
DeKalb County.
At the DeKalb County Jail.
Yes.
Which is a different county than the county we're in today.
Yes.
These gang profiles that y'all create, do you share them with other agencies?
If they ask for them, yes.
Okay. Have you looked into gang profiles of other agencies for the same individuals?
I have asked for DeKalb County for this individual we're speaking of today.
Okay. You had asked, and what did you get as a result of you asking that?
I got a gang profile from that department.
For what department?
DeKalb County.
When did you get that?
I don't recall the actual date.
Was it like a few weeks ago, a few months ago?
No, it was months ago.
Months ago, okay. But you are DeKalb County, though?
Yes.
All right. So I'm confused. You being DeKalb County, you asked for DeKalb County's?
Yes, the DeKalb County Police Department has their own separate gang unit.
Okay. And who is in that gang unit?
different police officer detectives.
All right, who's the detective you spoke with about my client, Mr. Dorsey?
I can't recall his name.
Okay. And then when he gave you this profile, he just emailed it to you, or how did you get that profile?
He just emailed it.
Do you have a conversation with him?
No.
Okay. Did you go back with him and say, hey, my information checks, it's the same as yours, or hey, some of your information is conflicting. Did you do that?
No.
Do you ever do that?
Yes.
All right. Have you ever done that with regards to my client, Mr. Dorsey?
No.
Why not?
I didn't see the need to.
You don't see the need to verify information that you've collected and other agencies have collected?
He already said he didn't see the need to.
I sustain the objection.
With regards to the two profiles that you have, one was made by the Cobb County Police Department that you don't remember the name of that officer, is that right?
Yes, sir.
The other one was made by Investigator Taylor Smith, who was with the Cobb County Sheriff's Office, is that right?
Yes, sir.
Tell me a little about those profiles. Are they both the exact same, or do they differ in some ways, and in what ways?
No, they'll be different. The cab police will probably have more narratives of what they occur on with the individual on the street.
Do you know how the cab classifies, what information they use to classify somebody?
The cab police know.
Okay. Have you ever gotten a profile from the Atlanta Police Department?
Not that I recall of.
You didn't ask for one?
No.
Would it be beneficial to know what the Atlanta Police Department is saying about my client for your classification purposes?
It could.
Okay. Do you usually just do things by gut feeling, or is there a manual for you to follow when classifying somebody?
No, I think I'm not fair to that argument.
It is. I sustain the objection.
I'll rephrase, Your Honor. When classifying somebody, the things you do to classify them, are they just the things that you do because that's what you feel like doing, or is there an actual number of steps, a methodology given to you by the people who trained you?
Yes, it's certain things that we would do in order to classify somebody.
All right, and that is, so it's not just whatever you want to do. There's steps you have to follow.
Yes.
All right. Please tell us what are those steps that you have to follow in classifying somebody.
Investigate phone calls, conduct cell searches to try to find literature, things of that nature.
No, but listen, that's just...
Yes, it's no specific steps, it's just investigating.
Okay, so there's no specific steps. You just do whatever you want to do.
It's not whatever I want, but it's investigating.
All right. Now, do you know if other agencies follow the same steps you follow?
I don't know.
In this conference you go to, do they share best practices?
Yes.
What are those best practices that you've been taught about?
Well, as the agency, it's a lot of police departments, so their practices wouldn't be the same as mine in the sheriff's office.
Do you know what best practices means?
Any practice that benefits you the most.
Did you ever go to this conference? You're going there to learn, is that right?
Yes.
And as you're going there to learn, what did you gain from it? What did you decide, I'm going to start doing that because I like the way they do it?
Definitely phone calls.
Definitely phone calls. So you weren't doing phone calls before?
I was.
Okay. Have you ever learned anything new from this conference you go to?
Yes.
What?
Just how to prosecute different cases or bring about charges for different cases.
Okay. And you talked about that. You talked about part of your duties are to investigate and later prosecute. How many cases have you prosecuted as a result of your gang investigations?
Maybe 3.
Maybe 3. Do you remember those 3? There's not that many. Which 3 were those?
I don't know if I'm allowed to say their names or...
It's public record, right?
Yeah, I would ask you if you want to. If you could just describe the details of those people, if those people are not related to this case.
I'll sustain the objection.
Oh, I'm sorry.
So I don't think she objected to the question. She just objected to him saying names. But
yes,
if you could give the details of these cases.
I've had gang initiations where people were jumped in the gang. I had people getting stabbed due to telling or snitching in the gang.
That's 2. What's the 3rd one?
It's pretty much the same. Usually jumping and physical altercations for the same. I maybe had another one where it was a physical altercation.
Okay. None of those involved Mr. Dorsey, did they?
No.
Okay. What gangs were involved in those that you prosecuted?
Bloods.
Bloods is a very general term, isn't it?
Yes.
Okay, which Bloods?
G-Shine, sex, money, murder.
Okay. Now, you said that you determine leadership in part based on phone calls. Is that right?
Yes, sir.
Because when people want to do something, they have to get permission from leadership. Is that right?
Yes, sir.
You made a very big claim that my client, Mr. Dorsey, is sex, money, murder leadership. Is that right?
I did hear that at one point in time, yes.
You heard that at one point in time. When did you hear that?
Months or maybe a year ago.
A year ago? Mm-hmm. What did you hear?
We heard that Mr. Dorsey was over the sex, money, murder, bloods over the jail.
Is that what you heard somebody on the phone saying, Mr. Cordarius Dorsey is the chief executive officer of sex, money, murder? Is that what you heard?
Not in those words.
Okay, well, then tell me what the words were.
The words were, yeah, his nickname, Juicy Boy Polo, he's running things in here.
Okay. Who was in that phone call?
I don't recall the name.
Do you have that phone call saved?
I don't know.
So you don't know who was in the phone call, and you didn't even save the phone call.
I could have said, I just don't remember if I did.
You guys have the capability of saving calls.
Yes.
Right. Now, I guess you don't have more information about that, so let's move on. Sometimes in calls, you determine somebody is leadership because they need to give the blessing for something to happen. Is that right?
Yes.
They need to approve a murder. Is that right?
Yes.
More specifically, I think you said that they need to approve the murders that happened at the DeKalb County Jail. Is that right?
Well, sometimes assaults, yes.
Okay. Or sometimes assaults. How many murders have taken place at the DeKalb County Jail since you've been there?
Murders that's gang-related?
No, first let's start with murders. How many murders inside the DeKalb County Jail have taken place since you've been there?
One.
When was that?
I don't recall the year, but it was years ago.
Years ago?
Yes.
My client was at the DeKalb County Jail. He was an inmate there for some time, is that right?
Yes.
Do you remember when he was an inmate there?
Maybe 2019, I don't remember the exact year.
Maybe 2019. Through when?
He just said he didn't recall exactly when Mr. Dorsey was an inmate there.
I don't think that's what he said. The first he answered, my first question was when did he get there, and my second question is when did he leave, and he should be able to.
Well, if he knows, do you know when he arrived and when he left, sir?
No, I don't recall the exact date.
Okay. This murder you speak of, did it happen while my client was there?
No.
Okay, so unrelated to my client, that murder?
Yes.
Was that murder gang-related?
No.
Okay, so you testify in direct that you can identify leadership because they give the approval for a murder, but is it right to say that there's been 0 murders since my client had been at the DeKalb County Jail?
Yes.
Is that because he prevented anybody from killing somebody?
Not of my recollection.
You don't know if he saved a bunch of lives?
I don't know.
Okay. Now, you also said there's some assaults. Sometimes they got to get blessings for assaults. Is that right?
Yes.
I am going to assume there's been quite a bit of assaults and jumpings since you've been there.
Yes.
All right. How many of those assaults were approved by Mr. Dorsey?
I have no knowledge of how many that's been approved by him.
So first, one of the factors is somebody giving permission to commit acts at the jail, puts him in a leadership position, right?
Yes.
But you don't have any for Mr. Dorsey?
No.
What other factors do you determine when you're trying to see whether somebody is leadership or not?
It would just be through phone calls and different interviews with inmates stating.
Okay. Have you spoken with anybody that has told you that Mr. Dorsey is leadership?
No.
So today, you've testified in direct that you have determined his leadership. Is it fair to say that the only factor that goes into that determination, into your, potentially your expertise, your expert opinion, is that one phone call that you don't remember?
Yes.
All right. Who are the other leaders of sex, money, murder at the DeKalb County Jail?
I have no knowledge of that right now.
You are the gang expert at the DeKalb County Jail, right?
Yes.
Who are the, first tell me the structure. I know a little bit about police structure. You know, you have captain, chief, lieutenants, sergeants, deputies, and all that military, not as much as the court, but you tell me what is the structure of the sex money gang at the DeKalb County Jail?
I can't tell you an exact structure at the jail.
No, don't tell me the exact one. Tell me whatever you got.
I just go by from what I investigate and hear on phone calls or what I might learn from different things that I find through cell searches or something like that.
Cool. Based on that, tell me from what you just said, phone calls, cell searches, literature, what do you know or do you think you know about the structure of sex, money, murder at the DeKalb County Jail?
I don't know. I will go based off of what a person said on phone call, or if they say they're running things, that would be my...
So you don't know?
No.
I don't think there's a point to keep going on. No further questions.
All right, anyone else? Yes, Mr. Wright, go ahead.
Good to be back up here. Hello, sir. Quick question. In DeKalb County, you said you're not familiar with YSL, correct?
Yes.
As in correct, you're not?
I'm not familiar yet.
Okay. And you're not familiar, well, I think you said Billy's, correct? You know them.
I know them.
And sex, money, murder, correct?
Yes.
And these are all separate gangs, correct?
Separate gangs under the blood gang.
Okay. But as far as you know, does YSL, is it just some sort of conglomerate, some big group that everyone gets to belong to? Is
Your Honor, I'd object. We're not trying to qualify him at all in YSL. He's
I
not
sustain the objection.
going to speak on YSL.
And your familiarity, or I think it's about 2 to 3 years back that you started your training?
Yes.
Okay. So you wouldn't know anything going on back in 2015 related to gang activity, correct?
Yes.
Okay. Thank you.
All right, anyone else?
Just one or two questions, Judge. Well, just a few.
One or two?
Just a few questions.
Okay, oh. So you've learned, you got the Menendez method, huh? Is that right? Okay, all right.
All right. Investigator Hall, I heard you use the word prosecute, that you have assisted or you've prosecuted at least, not at least, you said 3 cases, gang cases at the DeKalb County Jail. Is that correct?
Yes.
Does prosecute mean that you testified in court in regards to those cases?
I've done hearings, but I haven't been to actual trial for the cases yet.
Okay. You've never been called as a witness at a trial of a case involving any sort of gang activity at the DeKalb County Jail?
Yes.
You have never been qualified as an expert. Is that correct?
That's correct.
All right. And in regards to your duties at the jail, you classify individuals at the jail. That's what you testified to, right?
Yes.
And that is based upon a variety of different information that you get. You can get it from a hearsay statement of another officer, correct?
Yes.
You can get it from a document, or your duties can get that information from a document prepared by somebody else, correct?
Yes.
That you have no personal knowledge of yourself, right?
Yes.
You can get that from a phone call that you might listen to, correct?
Yes.
Just a phone call like anybody else could listen to, correct?
Well, they would have to have the rights to listen to them in the jail, but yeah.
Sure, but I mean, if hypothetically a phone call is made at the jail and it's provided to, let's say, me in discovery, I can listen to that same phone call and get the same information that you get from that phone call, right?
Yes.
Okay. Do you have any idea, sir, how often inmates are wrongly classified as belonging to a gang or not at the jail?
No.
Okay. That's all I have.
Yes, Mr. Short.
Thank you, Your Honor. Please support.
Sir, how are you?
Good.
Max Shard on behalf of Shannon Stillwell. You've never met my client, Mr. Stillwell, to your recollection, have you?
No.
You've never met my client, Mr. Stillwell, to your recollection, have you?
I never met him.
Okay. I just want to talk to you. I'm not going to ask you anything about Cordarius Dorsey. I just want to talk about your methodologies. When Attorney Jimenez asked the steps you followed, you spoke about listening to phone calls and looking for gang literature, correct?
Yes.
Okay. To me, that's talking about your sources of information. I don't want to talk about your sources. I want to talk about, once you have the information, how do you make the call about if someone's in a gang and what gang they're in, okay?
Okay.
All right. So, you've attended conferences?
Yes.
Okay. To your understanding, as a gang, you would consider yourself a gang investigator, correct?
Yes.
Okay. To your understanding as a gang investigator, is there a universal classification system used across the United States?
I wouldn't say universal. I don't know the other agencies' practices involving their classification.
Well, do they teach a certain classification system at the conferences that you attend?
No.
Okay. Are there a specific list of factors that you have been taught to consider before you determine if someone is in a gang or what gang?
Yeah, it would be based on investigating.
I understand that you investigate, but after you're done with investigations and have compiled all your information, do you have a set of factors that you consider to determine if someone is in a gang or not, and if so, what gang?
It would be based off what they give us or what we find. If I'm understanding the question right.
Well, you indicated that if someone says, I'm in so-and-so gang, when you talk to them, you might consider that in making a determination if they're in a gang.
Yeah, I would consider it, but I wouldn't just base it off that one statement alone.
Okay, so you would find it to be incorrect methodology to identify someone as a member of a specific gang based solely on self-admission.
Solely off self-admission, I would say it needs to be more investigating to find out if it's true.
Okay, so as an expert in gang investigations, basing it solely off of self-admission would be incorrect.
No, but I would say that you need to investigate more, find out more things to prove that that person is part of that gang.
Right, so it'd be incorrect to base it solely on self-admission. Okay. What other factors as a gang investigator do you consider?
Tattoos, the gang literature, as far as the jail, what we find, maybe statements by the person.
The person being the person you're investigating?
Yes.
Okay. And in your testimony is there's not a nationally, universally recognized scoring system or anything like that?
No, not universally recognized.
How about in Georgia? Is there a Georgia universally recognized scoring system?
No, not that I know of.
How about DeKalb County?
Yes. We do have a scoring system.
Do you use that scoring system?
Yes.
Okay, well, how does that scoring system work?
It's based on a certain amount of points. Maybe over 10 points, you would be considered a gang member, or 6 to 8 points, you would be an associate, and it's depending on what questions that they answer.
Okay, well, what are the factors?
If they have, that they state state affiliation, or they state they got jumped or blessed in, or if they are, or the defendants with somebody else, is multiple that I can't all recall right now on the paper.
Okay. And these points, if something doesn't apply, do you get negative points?
No.
So you just add points?
Just add points.
Okay, and I'm not trying to trick you with something that you don't have in front of you. Do you have the ability right now to explain the point system to me? Like what's worth what points or anything?
I can't right now, no.
Okay, well, where is that located?
I will have that at my office.
Is it published anywhere by DeKalb County that the public can find it?
Possibly. I'm sure it would be published if requested.
Okay. All right, thank you. No further questions.
Anybody else? Yes, Mr. Williams.
Good morning, Angela D. Williams from Mr. Ryan. You're aware that people join gangs for safety?
Yes.
Do you classify someone who joins a jail for safety?
Yes, we will stick.
Do you know?
Basis.
I'd ask to clarify. She said, do you, she asked about people who joined a jail for safety. I don't know if that was just a...
Well, yeah, why don't you, I'll stand for Mr. Williams. Why don't you rephrase that?
Okay, do people join gangs in jail for safety?
Sometimes, yes.
Do you classify somebody who's in jail who joins a gang for safety?
Yes, we will still classify.
And do inmates get tattoos in jail after they've been through intake?
Yes.
Okay. Nothing else. Thank you.
All right. Anyone else?
Yes, Your Honor. Short, briefly. Well, I guess I should say less than 100 questions, Your Honor.
Oh.
So I just have to figure something out. Are you a gang expert? Are you a DeKalb County jail gang expert? Or are you a DeKalb County jail gang classification expert? What are you?
Your Honor, we've moved to classify him as an expert in classifications at the DeKalb County Jail.
Great.
Okay.
Which one are you?
I'm a DeKalb County expert in classifying at the jail.
Okay, so it's just classifying gang members.
Yes.
At the DeKalb.
At the
At the DeKalb County Jail. Okay. Now, in this role, do you have any experience or training going back to, I guess, the makeup of the gang, the history of all gangs, the hierarchy of all gangs, and I mean all gangs in the DeKalb County Jail?
It would be based on what I find and what I investigate in the jail.
So, well, your training isn't based off of what you find and investigate. My question was, from your training, do you get that information to go into what you're finding?
At some trainings, yes.
Okay, so tell me about that. What type of trainings do you get with the background, the history, the hierarchy of gangs that you've been trained to help you do your job?
I haven't been trained. Well, the trainings I've been to, it doesn't go into the hierarchies, but it goes to basically identifying and recognizing.
You would agree that not all gangs are controlled or even ran the same, correct?
Yes.
And you would agree that the Bloods specifically are completely different from the Latin Kings or the Crips or even the Aryan Brotherhood, correct?
Yes.
All right, so tell me your training and experience about, or what training experience do you have to separate certain gangs at certain times so you know who they are or you know where they are in the system?
As far as the jail, I would know by the literature that I find or the phone calls that I would hear.
And I get that you find stuff in your investigations. I'm still just talking about your training outside of your investigation. What are you trained to do that equips you to do that job? That's what I'm asking.
We are trained to identify certain tattoos that we will see. We will see maybe how they are talking, the lingo, maybe what flags they might be wearing.
Okay, so no specific training as to this is why I know it's a member of a blood, or this is why I know.
Yes, it would be things like a blood would have a 5-pointed star, or you might see a Latin King with yellow, or things of that nature.
Okay, and you put that into, I guess, this system when you're classifying a person, correct?
Would I put things that I found in my training, would I put it into that system that I...
Things that you learned in your training that gets you through your investigation.
Yes, I will put
you would
those
put that
together.
information in the system.
I will put that together, yes.
Okay, so in your experience, you already testified that people go into gangs for different reasons. So in your experience, is there any time when someone gets out of a gang?
I haven't experienced it.
You haven't experienced it?
No.
Okay, so through your training, you've never had a class where someone has said some gang members get out of a gang at some point in life. You've never had that training?
I've heard of stories where it's been people who say they've got out of the gangs, but I haven't myself just experienced somebody getting out of a gang.
And that wasn't my question. My question is through your training and experience and just common knowledge, because the state's calling you an expert, you know that there are certain times when people get out of gangs, correct?
Yes.
Okay. Now, once you've classified somebody as a gang, because that's your expertise, how do you declassify them if they get out? Have you been taught to do that?
No.
Okay. So basically, you just put stuff into the system. You don't know what happens afterwards.
Yes, you can mark them inactive or active, or if you have the knowledge, you can make a person an inactive gang member.
But I kind of just asked you that, and you said no. So let me back up. You put people in the system as a certain gang member.
Yes.
How do you take them out of the system as a certain gang member?
Well, we will mark them inactive.
Okay. Not take them out, just mark them inactive.
Yes.
Are you familiar that Georgia just got that new statewide gang database?
Yes.
Does the information that you put in that data or in your system go into that database?
No.
It stays only with you?
Yes.
All right. No further questions. Thank you, Your Honor.
All right.
Judge, just briefly.
Yes, Ms. Bernard, go ahead.
Thank you.
Gina Bernard for Jaden Myrick. Good morning, investigator. How are you?
Good. How are you doing?
So you are aware that when somebody gets arrested in DeKalb County, they go to first appearance, correct?
Yes.
And when they're at first appearance, every single person that comes in and is arrested is represented by, gets a public defender and is represented by a public defender, correct?
Yes.
And your interviews of these individuals comes after first appearance or before?
Usually after.
Okay, so you are interviewing people without their attorneys being present, is that correct?
Yes.
And you're not Mirandizing them either?
I've already objected to this line of questioning with a different attorney.
I stay in the objection.
Thank you, that's all that I have. Thank you.
All right, anybody else? Okay.
Good morning, Attorney Eric Johnson for Mr. Eppinger. Just had a few questions to ask you. You stated on your examination earlier that majority of your information regarding this classification is coming.
Use the microphone.
Sorry, Your Honor.
All right.
Kind of tall. But you stated on your examination that majority of your, I guess, expertise comes from listening to jail calls, correct?
Yes.
And also from reading stuff that you might see in someone's cell, correct?
Yes.
So with these jail calls, you have no way of determining the veracity of anyone that's on the phone call, do you?
Regarding who's talking?
I mean, as far as the truthfulness of what they're saying.
No.
So basically, you're taking what they're saying and speculating as to what it means, correct?
Yes.
Okay. Now, when you go into the jail cells and you retrieve the literature, you're speculating as to what that literature means, correct?
Yes.
Okay, so you don't have any signed statements from anyone saying this is what it means, any signed?
No.
Nothing like that?
No.
So basically, majority of the information or the conclusions that you have reached is mere speculation?
Objection, argumentative.
I stay in the objection.
So, I'll rephrase the question, Your Honor. So, is it safe to say that majority of your conclusions are merely your opinions and not based on any particular fact?
Well, it'd be based on what I think, the knowledge I gained from what I heard.
Right. But in your opinion of that information, correct?
Yes.
Okay, and it's possible that opinion could be wrong?
Yes.
Okay, thank you. No further questions.
All right. Anybody else, any other defense counsels wish to ask any questions of Mr. Hall? Okay. Argument.
Your Honor, permission to redirect briefly?
Okay.
Thank you, Judge.
Just request that the redirect is mailed together to whatever is scope of the process.
That's federal court. Yeah, okay. Georgia has no scope. Georgia has no scope rule. Remember? Okay.
Judge, I will keep
One
it to
witness,
witness
one attorney.
Yeah, one witness, one attorney, though, Ms. Love. You're gonna need to let your colleague handle that, though.
Your Honor, I would ask that the court provide
leave and provide the state, with the court's permission, the state can have more than one attorney, and I would ask for the court's permission to redirect the investigator on the stand. Please, Your Honor.
I have some discretion in order to do that. I'll allow her to do that.
And Your Honor, I will keep my questions tailored to what was asked on cross-examination.
Okay, all right.
Thank you, Judge.
We ask you just reserve an opportunity to recross if necessary, Your Honor.
Sure.
Thank you so much, Judge. Good afternoon, investigator. Good morning, is it still, Investigator Hall? How are you?
Good, how you doing?
Good. You were asked on cross-examination what training that you get in order to do your job. Do you remember being asked that?
Yes.
What is GGIA?
The Georgia Gang Investigators Association.
And do you obtain information during training with GGIA that helps you to do your job?
Yes.
Is this information that is generally known to the public?
Not all the time.
Okay. And do you obtain information from other gang investigators during the sessions that you have with GGIA?
Yes.
Yes.
Respectfully, Your Honor, I know Honorable Deputy Attorney Melville's not here, but ask an answer. They were asked by us already.
Well, she got here when you all started your examination, your cross, so, and she may have been here a little bit before that, but.
Ask an answer.
Not by me, Your Honor.
I'll overrule the objection. Go ahead, madam.
Thank you. And do you obtain information from those sessions with GGIA that aids you in doing your job?
Yes.
And are the sessions with GGIA open to the general public?
Yes.
Are you telling me that anyone can walk in off the street and go into a GGIA conference?
Hold on.
Your Honor, I'm clarifying.
I'm gonna overrule the objection. Go ahead.
Yes, you would have to. You would have to pay, but yes, you would. Anybody could.
And when you say anyone could, can anyone come in and talk or present at those GGIA sessions, or are they limited to people within the Georgia Gang Investigators Association?
Basis.
I do not believe that this is the scope of the cross-examination.
Remember, Georgia has no scope rule. It's a thorough and sifting cross-examination. Plus, I believe that Ms. Love is just trying to flesh.
Who just said it's redirected?
Miss Bernard.
Yes, Your
All right. Yeah, I understand that, but it's all right. Since she's back on direct, okay. It's still there's still relevant questions related to his knowledge and experience, so I'll allow it.
Thank you, Judge.
All right. Ms. Bernard, anything else, madam?
No, but I'm objecting to that.
Sure. Okay. All right.
The information that you obtain, or the information that is given out, the information through the speakers, are those speakers anyone off the streets, or are they Georgia Gang Investigator Association members and invitees?
They're members and invitees.
Okay. You were asked whether the information that you use to classify or the opinions that you draw from the information that you hear defendants speak themselves, whether or not you speculate about their meaning. Do you recall being asked that question?
Yes.
What is false flagging?
Claiming something that you're not.
In your experience as a gang investigator, is false flagging something that is okay to do?
No.
Why?
Because you're representing a gang that you're not a part of. It's disrespect to the gang members.
And based on the information that you've received during training and your experience as a gang investigator, are there repercussions to false flagging?
Yes.
Your Honor, relevance to this question?
Yeah.
All right. Hold on, madam. You want to answer that, and then I'll take Mr. Jimenez after that. So.
Yes, Your Honor. The witness was asked on cross-examination whether or not he speculates about things. He was asked whether or not, or the significance that he gives to information that he hears defendants speak out of their own mouths. I am asking this witness to clarify, based on the questions asked during cross-examination, whether or not or why he gives what value he gives to the information that he receives. And I'm laying the foundation for that answer.
This question also crosses speculation.
I'm going to overrule your objection. Yeah, hold on, Mr. Jimenez, you have a...
Yes, Your Honor.
You have an objection on that question?
On that question, Your Honor, my ending line of question, my objection is relevance. And the basis is because we are at a Daubert hearing. We're not here for him to tell us whatever she's trying to get at. We're here only to look at the Daubert factors. I'm sorry, I kind of sound like a mistake, but we can see whether the testimony is based on sufficient facts and data, reliable principles and methods.
Mr. Jimenez, here's the thing with Daubert. When you're dealing with non-scientific witnesses like he is, the Daubert factors may not apply, but it more so you look at knowledge and experience of the expert rather than a particular methodology. So I have to evaluate some other things. I mean, I'm not supposed to ignore all the factors if there are some other factors that apply, but this pertains more so to knowledge and experience, and she's clarifying some of the things that he brought up during the fleshing out more of the direct. And they're relevant for the court's analysis as a gatekeeping function.
Thank you, Your Honor.
Hold on.
To make it very clear that when we were trying to get into very similar questions, we were objecting over relevance because of Daubert. And that's fine. I understand that. I just want to say that whatever's good for the goose is for the gander. If she can ask, we should also be allowed to ask. If we can ask, neither should the state. Thank you, Your Honor.
All right, well, remember, gatekeeping is different than cross-examination and weight and the jury's issue on credibility. Ms. Bernard?
Your Honor, my objection is, in addition to what my colleague indicated and my other colleague indicated, this is beyond the scope of the redirect. And that is my additional objection.
Okay, so noted. Mr. Harvey, did you have a... You just stretching? Didn't want to ignore you, okay?
And for the record, it's what's sauce for the goose is sauce for the gander. It's the goose gander rule, which has been adopted by the Georgia Court of Appeals.
Too much sauce.
All right, okay. Madam, I've overruled all their objections. You can proceed.
Thank you, Your Honor. Investigator, would you please tell the court what it is that is, or what are some of the repercussions, rather, of false flagging that you know of based on your training and your experience?
Physical assaults or any type of assault.
And have you had occasion through your investigations and through your training to see evidence of and instances of retaliation based on false flagging?
Through my investigation, I haven't had to deal with that.
Have you seen it during your conferences with GGIA, during presentations? Have you seen instances of retaliation due to false flagging?
Yes.
I'm sorry?
Hold on. Yes. Hold on. Basis, Mr. Menez.
I'm happy for leading. That's what it says.
I stay as the form. All right.
And Your Honor, thank you, Judge. I will ask the court to, once the state does ask a question, the fact that a question contains a yes or no answer, the case law, and I can present it to the court and to Mr. Menendez, is clear that yes or no answers are not leading questions that have yes or no answers. Rather, if I were to ask, isn't it true that X, Y, or Z is a sign of retaliation for false flagging? That may be a leading question, but asking whether or not, if, is this a sign of false flagging? Yes or no does not make it a leading question. If I suggest the answer by saying, isn't it true that this is a sign of false flagging? That's a leading question. But asking, Is it sunny outside? Because it's a yes or no question does not make it a leading question. If I said it's sunny outside, isn't it? That would be leading, and I'd ask that.
I would rather you just use the who, what, when, where, why, how.
I can do that, Judge. Yes, sir.
That's a lot easier.
Thank you,
Okay?
Judge.
All right.
Yes. And during your conferences and during your sessions and training with the GGIA, what type of things or information are you able to obtain that isn't necessarily available to the ordinary public? I'm asking a broader question now.
Information on different cases that's been completed and prosecuted, different tattoos from prison gangs, or different maybe videos that they have of altercations or things of that nature.
How is it that the training that you receive as a member of GGIA, how is it that you obtain information, if you do, that isn't available to the general public en masse?
A lot of the information is available to the general public as far as the basic knowledge of the gangs.
What about specific instances of gangs and crimes that are being or still under investigation?
Yes.
That information available to the general public?
No.
Now, you said you work in classification at the DeKalb County Jail?
Yes.
Why is classification at all concerned with whether or not detainees are in a particular gang?
Objection, Judge.
Basis.
It was asked and answered and on direct, the first direct.
Yeah, I'll sustain that.
Let me ask it differently. Is it
Order in the court.
Wait till the question's propounded, all of you. All right, madam.
Would you tell the court ramifications of improperly classifying detainees as far as their gang membership is concerned?
Objection, Judge. It was asked and answered when she asked the question about false flagging.
I would tend to agree with that.
Your Honor, as far as the classification, false flagging is one thing. Having someone say to an officer, I'm a Blood, I'm a Crip, I'm YSL, and any kind of ramifications that may come from that from another gang member is one thing. Asking the investigator what happens if they unintentionally put a YFN member in with a YSL member is a different question altogether.
I'll reverse my decision on that one. Go ahead and ask it.
So, what are some of the ramifications of improperly classifying detainees?
The inmate could be placed in a pod with a different gang or a gang that could assault him for being misclassified.
You were asked, I believe, by one of the last counsels for defense that crossed you, several questions regarding whether or not you are speculating when you draw certain conclusions. Do you recall that?
Yes.
When you make a determination in terms of classification, do you rely solely on information from one source that is not supported by anything else?
Objection, Your Honor. That's a leading question.
I sustain the objection, Mr. Foreman.
I'll ask a different question. Would it be proper to make a classification decision based solely on one thing without any other information?
Objection, Your Honor, that's also legal.
And that's an answer.
I'll sustain it.
Do you use multiple or only one thing to make your determination
That's an answer.
in terms of classification?
I'll allow that one.
Multiple.
I'm sorry, what?
Multiple.
Multiple?
Yes.
And do you take any safeguards to vet the sources of your information?
Yes.
Okay. And are the safeguards that you take means that are always available to John Q. public? Or do you have resources and databases that are law enforcement only?
Yes, we have resources that are law enforcement only.
And are those resources some of the things that you use in classification or not any of the things that you use in classification?
Those are some of the things that I use.
Okay. To work in classification, did you have to have any specialized training in gang identification, culture, and protocol, or did you not have to have any just to work in classification at the DeKalb County Jail?
It was not mandated, but it was highly recommended to have the training.
And when you say that it was not mandated, what was mandated in order for you to be an employee in classifications at the DeKalb County Jail?
But we had to have some type of experience on the floors, but we had to take classes sooner or later. We had to take classes.
What type of experience on the floor did you have to have when you signed up and applied to work in classifications? What kind of experience did you have to have, and what kind of experience did you represent that you had?
Your Honor, compound question.
I'll stand as to form. Just break that up, Ms. Long.
We're going to break that up, okay? What kind of experience did you have to have in order to get your job in classifications? Not the kind that was recommended, but the kind that you just had to have, baseline.
I had to have experience working the floors, actually working in the pods with the inmates and doing everyday activities with the inmates.
Why?
Because I couldn't have the position without having some type of knowledge of what goes on in the jail.
I'm sorry, I could not hear you.
Hold on.
Ask an answer. We've been through his CV.
Yeah, I'll sustain the objection now.
Your Honor, that question specifically was not asked. Why it is that he had to have that baseline experience, that was not asked. So this broad objection based on what was asked during direct.
I'll reverse myself on that one. Okay.
Thank you, Your Honor. Why is it that it was important that you have personal knowledge working with inmates in the pods in order for you to get the job that you have?
So I had to have familiarity, some understanding of what goes on in the jail and the inmates and the everyday activities of the inmates.
Why?
Because it would help me understand what I need to look for as far as investigating and conducting my classifications.
Does everybody in the general public have that same experience?
No.
Now, you spoke about what was highly recommended. Why is it that gang training is highly recommended for the job in classifications?
Because you have to know information about the gangs and identifications before you try to classify anybody.
And did you indicate on your application for the job you now hold your specialized gang training?
Yes.
Okay. And apart from what has been covered in direct and cross, what did you put on your application? First of all, were you truthful in your application?
Yes.
And what training did you put on your application that you possess that caused you to get this job?
Objection, Your Honor, speculation. He doesn't know why.
Your Honor, he got the job, and I'm asking simply what training he listed on his application for the job.
That's stage 17, it's already been admitted, so.
Your Honor, his resume has been admitted. I'm asking what he listed on his application for the job.
That's fine, Your Honor, but she said that caused you to get the job.
That's speculation.
I'll change the format if the court will permit me to do so.
I'm still
Oh, yes, Your
going
Honor.
to sustain the objections to form.
Yes, Your Honor. On your job application, did you list all of the training that you indicated on your resume?
Yes.
Did you list any additional training that you did not indicate on your resume?
No.
Okay. You were asked on cross-examination about proper protocol in making classifications. Do you recall that, whether or not you have certain identifiers that you use in order to classify a person as a member or an associate of a gang? Do you recall that?
Yes.
All right. Is that process one that is as simplified as 1 + 1 = 2, or is there a degree of subjectivity that goes into making your classifications?
It's a degree of subjectivity.
Is that subjectivity in any way based on your own experience working with inmates and working with gangs and
Yes.
other training? And how many persons are currently qualified to work in classifications in the position that you hold at the DeKalb County Jail? How many of you are there, if you will?
There's 2 of us.
And how many inmates would you say you have a responsibility for the classifications for?
As far as inmates in the jail, period,
Yes.
there's over 1,000 inmates in the jail.
Are the 2 of you solely responsible for making those classifications?
Yes.
And do both of you work at the same time on a particular inmate that is being classified, or do you have different inmates that you're responsible for classifying?
It would be different inmates.
Were you asked previously how many inmates that you've classified so far?
Yes.
And how many do you know overall have been classified since you have been at the DeKalb County Jail?
Over 50. I don't have an exact number.
Okay.
Let me ask a clarification question. Is it 50 that you classified as gang members, or is that correct?
Yes, yes.
Okay.
And do you classify every person who comes into the DeKalb County Jail as a gang member?
No.
How many, if any, retaliatory or acts of violence have you had or that you are aware of at the DeKalb County Jail based on a misclassification since you've been there?
Objection, Your Honor. This has been asked and answered already.
I'll sustain the objection.
Are you aware of any acts of violence that have occurred as a result of your misclassification?
No.
Would you be aware? Would you be made aware that, hey,
You said this person was YSL and they're YFN, and you put them over here and they got beaten up. Would you be made aware if that happened?
Yes, the inmate would state it.
Would your superiors let you know?
Yes.
Would it be something that would be formally addressed with you
Yes.
by your superiors?
Yes.
And that's never happened?
No.
How many times have you been subjected to this type of examination? How many times have you had to ever undergo this sort of rigorous questioning?
And let me add the objection also as irrelevant.
Yeah, I'm going to sustain.
I withdraw. Thank you, Judge.
All right.
You were asked by, I believe, Mr. Chada about his client in particular and what gang his client in particular was classified as being a part of. Do you recall that? You were shown some documents. Do you recall being asked about Cordarius Dorsey?
Yes.
In that regard, following up on that just a little bit, is it the case in Georgia that you can only be affiliated with one particular group, or in Georgia, are there things such as hybrid gangs or gangs where you're affiliated with more than one group?
Your Honor,
Basis.
these are compound questions that are being, and these are leading questions that are being masked as non-leading by making them compound, when she already gave him the answer she expects. There's a lot, this feels like a police interrogation, where they're telling him what they want to hear. Some of the examples are...
I got it. I agree with you. It's in terms of form. I sustain the objection.
Thank you, Your Honor.
Okay.
Are you only allowed to be associated with one group in Georgia if you're a member of a gang?
No.
Say that louder, please.
No.
Okay. Are there any groups in Georgia that you would have classified as a gang that has elements of multiple gangs in them?
Objection, Your Honor. This question calls for speculation.
Repeat the question one more time.
Are there groups in Georgia that have been classified as gangs that have elements of multiple gangs in them?
No. I'm sorry, she asked if there were any groups that he would classify as gangs that have multiple elements of other gangs.
No.
No, I don't think so. I think their question was, are there, if he can answer it, I'm gonna overrule your objection. If
Your
he can
Honor,
answer
I
the
could
question.
object to the broadness of the question. I mean, by definition, every gang has multiple elements of every gang. I mean, the answer is obviously yes.
Multiple elements of other gangs is what I said.
It's still an extremely broad question. Like, the Aryan Brotherhood still has elements of Crips. I mean, what are we asking here? The question is too broad. Especially if he's supposed to be an expert in classification, and simply classification, not gangs in general.
Ms. Love, also saying this in form, it's overly broad.
Yes, Your Honor.
Go ahead and rephrase it if you can.
Thank you, Your Honor. I will. When classifying inmates for placement in the jail, are you looking for have you on occasion seen inmates who are members of groups that have For instance, a person, just for example, say there is a gang called the Orange Gang, and the Orange Gang has members from the Grape Gang, the Banana Gang, and the Apple Gang. This person comes in, you see grape, apple, banana. Have you seen instances where a person comes in identifying as one gang, and that gang has elements of other gangs?
Yes.
Just one moment, Your Honor. And have you been asked by the state or anyone else during the course of the pendency of this trial to speak on anything beyond the classification of inmates at the DeKalb County Jail?
Have I been asked other than the
Have you
classification?
been asked to do anything other than speak about how it is that you go about classifying inmates at the DeKalb County Jail in preparation for this trial?
No.
Thank you. That's all that I have for now, Your Honor.
All right, any additional cross?
Just argument, Your Honor.
Well, I didn't ask that yet, okay? I asked, is there any additional cross? All right.
Mr. Johnson for Mr. Eppinger. You were asked on redirect, basically regarding your knowledge and whether or not as to whether or not that some of the information that you learned was public knowledge. Now let me ask you this: the gang that we were speaking about, the sex, money, murder gang, what area of DeKalb County do they operate out of?
Objection, Your Honor. Relevance.
The relevance is, Your Honor, he's basically stating that the state asked him questions about whether or not he had information that was not readily known to the public. I'm trying to establish his situation.
It's not relevant for Mr. Carter, at least for what he's being tried to be qualified for.
I mean, it's just a response to what was asked on redirect, Your Honor.
But you're asking him something that's not relevant.
So, is it your position?
I stand the objection.
Okay, is it your position today that only a person in your position would know what a gang tattoo is?
Objection, Your Honor. Grossly.
I stand the objection.
And what's the basis for the objection?
Argumentative, grossly mischaracterizing any particular testimony.
There's a couple bases. So,
So is it of your opinion that the existence of gang tattoos is something that is not known by other individuals in the public?
No.
Okay. So it is possible for members of the public to know and to be able to identify gang tattoos, gang markings, gang colors, gang insignias, gang...
Objection, compound question.
I'll break it down, Your Honor.
And Your Honor, also objection as to asking the witness to get into the province of the court in this hearing.
Your Honor, the state made numerous attempts in bolstering this witness to say that his knowledge was something that the public did not know. I believe there are 4 or 5 questions asked for that particular point. So I'm basically coming back asking, are this information something that the public would know? Because one of the factors in consideration at Daubert is that he would be able to say something to assist the public that the general public would not know.
Assist the jury.
Assist the jury of something that they commonly don't know. To basically say that he has testified that majority of his information has come from individuals in the jail and stuff that he found in their rooms and stuff like that. Although he has received specialized training about this, when he's been classified as an identifications expert. So if the identifications that he's used and he's testified about are the markings, the tattoos, gang insignias, I believe he mentioned flags and all of these other things, the state made the effort to say that the knowledge of these things are not within the purvey of the public and the common individual. I'm just merely asking questions to establish that they are. that the things that he's talked about.
Okay, all right.
So
I'm gonna overrule the objection. Go ahead.
Thank you, Your Honor.
Thank you. So, is it possible for the public to know, individuals in the public or throughout the area that...
Speculation, is it possible?
Okay. Well,
This has to, do you know?
do you know if individuals in the public know about gang markings?
Yes.
Has your experience and training shown you that?
Yes.
And would you say that these individuals may also know about gang insignias?
Yes.
Objection calls for speculation.
Okay. Well, are you aware that the public has knowledge of, through your training and experience, have you encountered individuals of the public who have knowledge of gang markings?
Yes.
Through your training and experience, have you encountered individuals of the public who have knowledge of gang insignias?
Yes.
Through your experience and training, have you encountered individuals who have knowledge of gang colors and tattoos?
Yes.
Okay. So based on your experience and training, is it safe to say that individuals in the public, that knowledge of these particular things is not something outside the knowledge of the general public?
Objection, Your Honor. That is within the court's purview to make a determination
Yeah, I'll
whether
sustain the
his...
objection.
No, I'm asking his opinion.
But still my determination.
Well, I believe I made my
point. In terms
point.
of that particular last question.
I believe I made my point, Your Honor. No further questions.
All right. Anybody else? All right, Mr. Boss.
David Boston, Mr. Stillwell. You ever testified in court before?
Yes.
As to,
Answered, Your Honor.
I believe he said he'd never been qualified.
I don't think he's been qualified, so yeah, he can ask it. I'll rule the objection. Go ahead.
Pertaining to classifications?
Yes.
Were you determined to be an expert in that area during those?
I wasn't labeled an expert.
Judge, asked and answered.
I want to know that because I don't think I want
Yes, Your
that to be clear or clarified.
Thank you.
I wasn't.
He was not. I don't have anything for it.
So you have not been qualified as an expert, Mr. Hall?
No.
Have you been qualified as an expert in any other area or gang affiliation or gang classification in any of the courts in Georgia?
No.
How many oh, you did say earlier that you've done at least 50 classifications of gang members at the DeKalb County Jail. Is that right?
Yes.
Okay. And you've been a police officer since 2014?
Yes, I was a detention officer in 2014, and I was a peace officer in 2021.
Okay. Anybody else have any questions based on the court's questions? Okay. Argument now, Mr. Jimenez.
The state wants to go first, so I'll go first.
Now, you all go first, and I'll let them respond. Can we ask Mr. Hall to stay? Mr. Hall, just stay there for a second. Okay, all right. Go ahead.
Sudi Documents on behalf of Mr. Dorsey. May it please the court state. It's, you know what I'm going to ask? I'm going to ask that you do not qualify him as an expert. And basically the reason for that is because the testimony today showed that he just doesn't meet the qualifications. He doesn't meet the standard to be qualified as an expert. There's very likelihood that there is a body of work out there where people are able to classify and understand and identify gangs.
Wouldn't you have don't you have the ability, and I'm not saying your client has any responsibility to present any evidence in this case, but wouldn't that be the area of a contra expert or somebody that somebody would come in here? Because remember, we're dealing with non-scientific specialized knowledge. So the state basically has offered Mr. Hall to say, okay, look, I've got about 10 years of policing and detentions experience. They're classified. They want to classify him as a, in their words here, as a gang classification expert at the DeKalb County Jail, and he's been in some training in terms of classification classes in in 2022. He's testified about some other things. He has about 100 hours of gang training. He's listened to 1,000 hours of phone calls, and he's familiar with gang tattoos. So, you know, in terms of the, you know, the court looking at that, deal with the issue of this particular expert. It may be, or I think the state's trying to qualify him by experience.
Absolutely, Your Honor. That's not the argument. No, that's, and I'm just trying to get to there. I'm going to be hopefully not too long-winded, but, Your Honor, certainly there is a body of expertise out there for people that classify people in gangs. Ideally, yes, I can call my own experts. And if that comes to that, hopefully the state won't get into that because that'll be burden shifting. I ain't got to call nobody. It's not my burden.
You don't. And I don't want you to think that, that this court's going to impose that upon you either.
Absolutely. Thank you, Your Honor.
All right.
But my point is, based on this, respectfully, officer, based on Officer Hall's experience, I say that yes, there's a body of work out there that makes this something that somebody can have an expertise, but he doesn't. He is not an expert. He's never been tendered as an expert. Actually, he's never, don't know if somebody's tried it before, but he's never been qualified as an expert before. I do know that with regards to the DeKalb County Jail classifications of gangs, he is top 2. But there's only 2 people there that have ever done that. So that doesn't make him an expert. I want to focus on 24-7-702, Your Honor. This shall apply to all proceedings, and a witness is qualified as an expert by knowledge, this is it, skill, training, education, may testify in the form of an opinion or otherwise. If, there's the big if, and that's when we get into the factors. The expert's scientific, clinical, or otherwise specialized knowledge, yes, there has to be, it doesn't have to be science, it doesn't have to be hard science, and that's the point. Everybody keeps focusing on Kumo tires, and that's what it said. It doesn't have, you don't have to be a scientist. It can be anybody. You can be an expert on social media. You can be an expert on Instagram and getting a bunch of likes. There's plenty of experts out there. So, sure, this body of work can be developed into an expertise. But if the knowledge will help the trier of fact to understand the evidence or to determine a fact and issue. With that point, in this case, I don't know how much help he can be to the jury, because when I asked him how do you classify my client, Mr. Dorsey, he only based it on, according to him, self-admission. We don't know. We don't object that's hearsay, but self-admission to somebody else, to a party that's not even here. They can call that investigator. That witness can come and be a witness. And you know what? That comes as a statement of a party opponent. It's going to come in. You don't need to bolster it by giving somebody the nice little badge of I am an expert. It's not an opinion. If it was self-admission, then just say it. And then the other only factor, he says he had a methodology that he created, and funny enough, he's gone through all this training, over 100 hours, if his math is correct, over 100 hours of training, where, I'm paraphrasing, but pretty much he said he didn't really learn anything from it. Whatever he heard that was good, that was a best practice, he was already doing. Jail calls, great. That's a great thing. And I'll submit to the court, absolutely, jail calls are crucial. When I used to be in the office under Mr. Howard, I would listen to jail calls like it was my iPod. I listened to those things 24/7. I was in court, I was at home, I was on my drive, I was listening to jail calls, and people say some really stupid things. You know what? Absolutely nobody said anything about my client. He claims that there's a call where somebody said something, but he doesn't have that call. He doesn't even remember who was in that call. That's the only other factor. He has not testified. He found any literature. He didn't testify as to anything else regarding to my client. So, if the only thing you have is self-admission, that's a statement of a party opponent. We're going to object to it. We're not stipulating that comes in. You're probably going to overrule my objection, but you don't need an expert for that. All you need is the other officer to say, yes, he told me that. And she doesn't need to be an expert either. Let's go on to the next factor. This testimony is based upon sufficient facts or data. It doesn't have to be lab reports. It doesn't have to be gas spectrometry or whatever the GBI experts were saying. Just facts or data. You know what data is? Intelligence, intel. What facts or data do you have about him? He spoke about it. I asked him, not even about him. We're not here for him as an expert on Mr. Dorsey. We're him as an expert on classification of the DeKalb County Jail. And you know what that expert would know? He would know who is the leadership of sex, money, murder, because that's one of the primary gangs. He can't even drop one name. Just tell me one name, Your Honor. All these great attorneys here, and you can just drop names. You can say Kumo, Dauber, Miranda. You're just dropping names. Why? Because you are an expert. You know your field of expertise. He doesn't. He doesn't even know who's running that jail, because apparently that jail is ran by Bloods. And that jail has been protected by these Bloods because there's been 0 murders since my client was there. And apparently he's the leader. So thank you, Mr. Dorsey, for keeping us all safe. But that's not the case. He doesn't know anything about these gangs. All he knows is that he read a report that somebody else wrote. He's not an expert. Moving on to the next one. The testimony is the product of reliable principles and methods. These methods, again, it doesn't have to be, I pour in a little bit of 5 milliliters into a beaker and I put it there into the heat for 50 minutes. No. What are your methods? My methods are same methods he keeps spitting out. I listen to jail calls, I do interviews, and you get literature. Those are the only methods. What are the best practices? When you went to Gypstick, when you went to all of these things, what are the best practices that you learned? Nothing. I was already doing it. He's so good. He doesn't need any training. I mean, this resume is lengthy, and he didn't really need it because he already knew all of that. What is the point of having training? Well, we all go to continuing legal education because we need to learn something. I am learning every day here. I am learning that, from now on, I need to refer to people as the Honorable because that is respectful, and I learned that from Mr. Steele. I'm learning so much stuff from Mr. Harvey. We're not working together. They're not in my team. We're co-defendants. We have antagonistic defenses. We're still being forced to go together, but I am learning from them because I continue to learn every day. This witness didn't learn anything from all this training, all these hundreds of hours of training. Let's go on to the next factor. The expert has reliably applied the principles and methods. Cool. Do you have principles and methods? As the gatekeeper, Your Honor, you are St. Peter. You're at the gate. You're telling people who can come in and who not. That is what a gatekeeper is. Again, I'm repeating the same thing I said yesterday. But as the gatekeeper, if you decide to classify as an expert, you're saying your principles are great. Your principles and your methods work. Yes, you came up with them yourself. You didn't need to learn anything from all these hundreds of hours of training. You already had it. But did you apply it? Did you apply it to this case properly? The only thing he has, someone else's report, and a call that he can't even pinpoint to or give it to us. He talked about a point system. He doesn't know the point system. If you ask me the Ayala factors, I can spit him out real quick. Ask him the point system for his expertise. He don't know nothing. I stopped asking questions because all the answers were, I don't know. Your Honor, Daubert wants to allow reliable and relevant evidence in. Kumo explains it doesn't have to be scientific. And General Electric Company gives us the standard. The standard is abuse of discretion. That is a very high standard. It is within your discretion. But, Your Honor, I will submit to you, this is going to be a 6 to 9 months trial. Not because of the evidence, but because of the sideshow they're trying to put up. They're trying to get everything in, everything that has nothing to do with the facts of this case. They're trying to bolster people by making them experts. Again, just tender into evidence whatever that legal classification was as a business record exception. Not saying that we agree with it, we will object to that. But it's a business record exception because it's part of classifications. When you go into the jail, you get fingerprinted. That young man or woman that grabs your finger and rolls it across is not a fingerprint expert. That is a technician that takes fingerprints. A person that asks you, what gang are you in, what is your name, date of birth, and social security number, that is not an expert. That is a technician. That is an intake officer. And that is a very honorable job. It is a risky job. Anybody that puts on a badge every morning and goes to work, whether it's in the streets or at the jail, is risking their lives every day. Does not make them experts. Stop trying to bolster all this testimony that could come in other ways They can prove their points in many other ways by classifying people as experts. Just on this particular set of motions, we are dealing with, we've been here for a week, going into after the court closes on these medical experts. I was never approached and asked. I mean, I know I'm not the shot caller, but we can stipulate all this medical experts. You don't need to put in, I think one of the experts that came in yesterday, I love his answers. Like one is, he's a medical expert, and he asked, have you ever been published? No, he's not an academic, but he's still an expert. Have you had any awards? Nothing beyond my paycheck, but he's still an expert. But you know what? This is what the trial is about. They are trying to get in all these people that are not experts, and if you mix them in with the actual experts, with the medical examiners, with the GBI forensic chemists, if you put them all there, then they all sound very important, but they're not. Respectfully, Mr. Hall, you're not an expert, and we ask the court that you do not allow them.
Your Honor, to the commentary addressed to the witness during Mr. Chada's argument, he's well aware.
All right, I'll sustain that point.
My apologies, Your Honor.
Okay, all right. Thank you, sir.
Thank you, Your Honor.
All right, anybody else wish to be heard in terms of argument before I let the state go ahead and finish up?
Your Honor, Sean Hoover for Mr. Sullivan. I'm just going to bring this up because we've heard what the state's going to say. I mean, we heard it all day yesterday.
Not yet. But
well, no, we heard it all day yesterday. We heard the script. What I'm saying is they're going to harp on the fact that this gentleman said that his training gave him outside information that the regular everyday person doesn't have. The testimony that he said was
kind of inconsistent on that. So
agreed. But the testimony that came from this witness was on different cases being prosecuted, which has nothing to do with what's going on here, and specific crimes that are being investigated. So the state's going to get up and say there's all this outside information. I just want to remind the court, put on the record, this witness didn't tell us any of that outside information. It applies specifically here. So he is not an expert. The information that he's providing is not relevant to any of the however many co-defendants are still left in this case. So I just want to make sure that's clear because I'm pretty sure we're about to hear that again.
all right.
Yes, Your Honor. Mr. Johnson for Mr. Eppinger. Your Honor, as it relates to this particular expert, looking at the Daubert factors, what that was brought up earlier, we can say that his techniques are not reliable in any way in this matter. He testified that majority, and I asked the question specifically, I'm not disputing the fact that he has received some training, but he testified that majority of his determinations and classifications comes from information that probably would not even be admissible in court. He comes from the hearsay statements of individuals on the phone that he cannot confirm the veracity of, and also statements that were written inside of a jail cell that he cannot say exactly who wrote them or anything else. And as Ms. Bernard brought up, all of these conversations take place when individuals are in custody, and most of them are represented by counsel, so would not possibly be admissible anyway. So, and also, Your Honor, as it relates to his classification and knowledge of the gangs, the district attorney who presented yesterday got up here and stated that Georgia, Atlanta has a gang problem. So to act like the public does not know about or have any knowledge about the gangs is kind of disingenuous. The state is going to allege through this trial that there's a great intersection between the gangs and the hip-hop community. So that in and of effect gives a wide range of individuals who would have knowledge about these things that we discussed as it relates to the markings, the identifiers, and all the stuff that he uses in his classification. This is not something that the public does not know about. There are 10-year-olds on the internet right now who are watching this online who know about all of these markings and things of this nature right now. So to say that he has some kind of specialized knowledge that the public would not be able to understand during the presentations of the state's course is somewhat disingenuous, and the fact that that information is based on evidence that will probably be inadmissible in court also does not make him an expert in this case. And so for those reasons, Your Honor, we do not believe that he should be qualified as an expert in gang identification at the DeKalb County Jail.
All right.
Thank you.
Anyone else? All right, Madam, Ms. Rosenwasser?
Yes, Your Honor. Your Honor, I'd like to start my argument with a quote from the Second Circuit. Although he had never been qualified as an expert witness, even the most qualified expert must have his first day in court. That's out of United States versus Locasio LOCASCIO 6F3D 924. That's the Second Circuit, 1993. Your Honor, this gentleman is absolutely qualified to offer expert testimony in classification of gangs at the DeKalb County Jail. So I'd like to start by responding to a few of the objections we've heard, particularly that according to the defense attorneys, gang knowledge is something that the general public has. Now, Your Honor, I don't dispute there are members of the general public that are affiliated with gangs, that know gang members, that are aware of gangs in the state, and certainly the General Assembly is aware that there's a gang problem, but that doesn't speak to the general public. I can tell you, Your Honor, when I started in the gang unit, I had a family member say, wait, do we have a gang problem? Just because these defendants are in that life and that there are people in the public that are familiar with gang tattoos and are familiar with gang lingo or gang expressions, that does not apply to the general public. We are in a big county, Your Honor, and to say that everyone in the public is aware of this specialized gang knowledge is just absolutely, completely specious argument, Your Honor. This individual testified, Investigator Hall testified, that he has specific information that he learned through training at the GGIA, which certainly not everyone can go to, and he has learned he's one of only 2 people that can do the classifications at this jail. And if he makes a mistake, people can die. And while Mr. Chadha wants to take credit for Mr. Dorsey keeping the jail safe, I think it actually speaks as circumstantial evidence the fact that Investigator Hall is reliably applying the methods, that there hasn't been a murder at the jail, that he has been able to correctly classify over 50 gang members so that there are not these incidents. The reason, as the court's aware, there is a charge in this case involving Mr. Dorsey attempting to arrange that type of thing. This investigator's job is to stop that through his classifications. That's what he does. The fact that no one has died speaks to the fact that he's good at his job, not that he's bad at his job and he doesn't know how to do it. There is circumstantial evidence that he's reliably applied the principle and methods. And, Your Honor, the question specific to, who wrote the report, who listened to exactly what, who made the jail call, that's all questions that go to weight, not to admissibility. And they are more than welcome to cross him at trial. They are more than welcome to call their own expert and say, he doesn't know what he's doing, he's wrong, my expert. I'm ready for battle of the experts, Your Honor. We can certainly do that, but that does not mean that this expert is not qualified. Your Honor, I'd like to point the court to a few gang cases that are out of the 11th Circuit, and I don't even remember which hearing I did this in yesterday, but I think I gave the court some of these sites yesterday, but I'd like to provide them again. United States versus Augustin is a pretty seminal case out of the 11th Circuit, and that's AUGUSTIN. That's 661F3D 1105. That's a 2011 case out of the 11th Circuit. And that was one of the first cases to look at gang expert testimony in the 11th Circuit. So, as I quoted yesterday, the 11th Circuit found, we note that Federal Rule of Evidence 702 does not define an expert in a narrow sense. And the court found, in the light of the substantial experience that Agent Young had with respect to street gangs, we conclude that the district court was within its discretion in determining that Agent Young was qualified to give expert testimony about the organization in question in that case. Here, we have the same situation. Investigator Hall has a ton of experience. All he does all day is make sure that he doesn't mistakenly classify someone, because if he does, people will die. He has looked at gang lingo. He has looked at gang writing. He has looked at gang literature. He has attended gang trainings. He has attended over 100 hours, even if he might not be great at math, but he's sure great at gangs, Your Honor, and he knows what he's talking about. He is aware of the different ways to classify these individuals when they come into the DeKalb County Jail. That is experience that he has. That's what he's gained from not only his training, but his years there. And as he testified on redirect, he's interacted with inmates. He knows them. He couldn't have got his current job if he hadn't spoken to inmates, if he wasn't aware of them, if he hadn't learned how to have conversation with these folks so that they will be honest with him and they will tell him what gangs they're affiliated with, and he's able to obtain that information. That's his whole job. And for the defense to claim that this is something that the general public is aware of, I think that's just absolutely misunderstanding the reality of the situation. While the general public certainly might be aware, okay, yeah, there's Bloods, yeah, there's Crips, sometimes they have tattoos, they're not going to know. I didn't know until this morning that 7 and 2 are Bloods lingo. That's something I didn't know, and I'm going to guess it's something that most of the people in the public don't know. Maybe people here do, but, Your Honor, that's not going to be something that somebody just coming out of their house one day and coming to jury duty, they're not going to know that. And that is exactly the type of thing that we need expert testimony to show, because the general public is just not going to be aware of those intricacies that someone is going to learn from years doing gang investigations, speaking to gang members, listening to thousands of hours of jail calls, and basically having these interactions day to day with gang members, Your Honor. This is the exact type of experience and knowledge that's necessary. That's why we need to have these experts to explain, so it makes sense why we're doing this, and we're not just calling someone off the street to be like, yeah, I think he's in sex, money, murder. No, this is someone who has understood that and can make the classifications and can explain why they've made those classifications. In United States versus Wilson, that's another 11th Circuit case. That was 2015. That again goes to the qualification of a gang expert.
What's the citation?
I'm sorry, Your Honor, that's 634 Fed APPX 718. Now, in this particular case, the court found that where the defendant testified about his, I'm sorry, Your Honor, where the detective testified about his experience and his training, and that how he had spoken to multiple gang members and about the gangs themselves, and showed the connections between the gang and why that was related to the case, the court found that that was going to be sufficient. And I want to point out something specific about Wilson that I think is important. At Penn Site 727 in Wilson, the particular gang expert that testified in Wilson was actually admitted as a general gang expert. This particular gang expert didn't actually have any direct information about the appellants in the Wilson case. He just testified about the background of the gang. And the court found that that was acceptable. The court found it didn't matter if he did not have personal knowledge if any of the appellants in that case were in the gang. It was that he was able to provide that specialized background about the Bloods gang in that case based on his training and experience and his the fact that he knew about how these gangs worked, his history, the traditions about gang membership, the distinction between West Coast, East Coast Bloods. He was able to explain statuses in the gang. He was able to explain tattoos in the gang. And that's a lot of what we heard today from Investigator Hall. And Investigator Hall even does have that boots on the ground knowledge, but I wanted to bring Wilson to the court's attention to explain that it's not a question of specifically, okay, it's whether he's an expert in this particular field. What he knows or does not know specifically about Cordarius Dorsey or what he's done on...
Part of it is application, though.
Absolutely, Your Honor, but I wanted to point that...
Dauber does require that, when you have training, when you have... with non-scientific specialized knowledge, you still has the testimony still has to be based on data, reliable principles, and the experts reliably apply the principles to the facts in this particular case.
Yes, Your Honor. So, we wouldn't call him if he had no knowledge of DeKalb County jails or any classifications, but I wanted to point the court to Wilson to show how far that is stretched, just to show the court that this is not a situation where he's in no way involved. Wilson absolutely applies. And the court in Wilson specifically found that this was something that was likely to assist the jury because it shows the import of the evidence in evaluating the alleged gang activity underpinning the conspiracy charge. Obviously, we have a RICO conspiracy here, and we also have Mr. Dorsey charged with a gang activity count as a result of his actions in the DeKalb County jail. So that is directly related, Your Honor. And the court found that this was highly probative, and here's why. They said evidence of the appellant's membership in or affiliation with the Blood Gang tended to make the prosecution's theory of the case more likely. So it was admitted in this case. Your Honor, another case out of the 11th Circuit that I'd like to point the court to is United States versus Lobo Lopez, LOBO-LOPEZ, 468 Fed APPX 186. That's an 11th Circuit case from 2012. And in that particular case, an individual was qualified as a gang expert. That individual testified that he had been assigned to a gang task force. That individual testified that most of his job focused on one of the gangs at issues. He testified that he'd gone to training at various conferences about gang activity. He testified that he had been involved in gang investigations and that he'd participated in surveillance of gang members approximately 50 times and had interviewed 50 gang members during his career. The court affirmed the admission of this expert testimony. The court found Rule 702 does not require that a court rely solely on an individual's education to qualify him as an expert. Rather, the text expressly contemplates that an expert may be qualified on the basis of experience. Here, and I'll just say the expert's name to make it make sense. Here, the expert testified to extensive experience in investigating the gang, surveillance the gang, interviewing the gang members, and training with law enforcement on this gang and another gang that was related. Accordingly, we cannot conclude that the district court abused its discretion in qualifying this individual as an expert on that particular gang. Specifically, the court found that the expert's testimony, quote unquote, shed light on the various rules, terminologies, and methods of the gang, and they concluded that the testimony was proper and that it should be admitted, and that the court properly admitted it. And there's a lot of cases from other states too with this same, other circuits too, and I do want to note that Rule 702 doesn't just confine courts in this state to looking at the 11th Circuit. It actually says specifically to look to all federal courts and other states. So briefly, Your Honor, United States versus Ledbetter, that was out of the 6th Circuit, and the district court in that case, a notable line that I want to point out is that an individual was qualified to testify as a gang expert, where the court found, notably this line, the district court sensibly noted that it could not imagine too many people having more credentials. So essentially, he said he's one of only 2 people that knows how to do this. He has the credentials, he has the experience, he has done this, he knows how to do it, and if he does it wrong, people will die. So he has a real incentive to do it right. And the fact that nobody's died speaks very, very highly to his abilities. Your Honor, additionally, specifically the court found in that Ledbetter case that the gang testimony helped the jury to determine whether the charged gang was a criminal enterprise.
What's the citation for Ledbetter?
Yes, Your Honor, I'm sorry. That's 929 F3D 338. That is a 6th Circuit case from 2019, and the spelling of Ledbetter is Ledbetter. And additionally in that case, and this is at Pin Site 348, the court said, as we said in United States versus Johnson, which is another case, courts generally have permitted police officers to testify as experts regarding drug trafficking as long as their testimony is relevant and reliable. There are innumerable trades and practices that employ their unique devices and codes that may mean nothing to the untrained observer, but may speak volumes to a maven qualified by experience or training. So I think that's what we have here, Your Honor. Contrary to the defendant's statements, while maybe their clients or someone else may have detailed inner workings about how a gang operates, your average layperson in Fulton County certainly does not know that 2 and 7 are Bloods lingo. They don't know that a 5-pointed star tattoo can go for the Bloods. They don't know this. This is exactly the type of stuff that he has learned only from years and years of interacting with gang members at the county jail and classifying those gang members. This is not something that you could take any old person off the street and just do. You couldn't. I've been working on this case for, 7-8 months. I think I'd do a pretty bad job trying to classify gang members because I do not have that same experience. I don't know what he knows, and I'm essentially a gang prosecutor, and I don't know that. So what he has to offer is way beyond
the ken of the average juror, Your Honor. This is exactly the type of thing that experts need to inform the jury about and explain why they're able to classify folks in the DeKalb County Jail. Your Honor, United States versus Hankey, Hankey, that's 203 F3D 1160. That's a Ninth Circuit case from 2000. And in that particular case, it just again says the relevant reliability concerns may focus upon personal knowledge or experience. And it also says what's kind of what I like to point out in this case at Pin Site 1169. Here, the witness had devoted years to working with gangs, knew their colors, signs, and activities. He heard the admissions of the specific gang members. He had communicated and worked undercover with other gang members. This type of street intelligence may be understood as either remote or hearsay, but FRE, Federal Rule of Evidence 702, works well for this type of data gathered from years of experience and special knowledge. That's exactly what I've been saying, Your Honor. He knows things that I don't know, and I'm sure a juror doesn't know. Maybe one juror might, but I can tell you, Your Honor, this is not the type of thing that every juror is going to know. There are jurors out there that might not even recognize what the legislature has, that we have a serious gang problem. They are going to need to be educated, and he can provide that education. That's exactly the purpose of expert testimony. Again, Locasio, I provided the court to that site earlier, and that again says, just because an expert's never testified before doesn't mean he's not an expert. Sometimes we have to be the first ones to pave this ground. And I think, Your Honor, it's important to note, of course, that 702, as applied to criminal cases, is brand new. So we're doing a lot of these. If it sounds like we're doing stuff for the first time, it's because this is a brand new statute, and we're having to make sure that they're qualified in a way that maybe we were not having to before. So that's why we're here today, Your Honor. And again, I'd also like, in Fourth Circuit, United States versus Thomas, 490 Fed APPX 514, a gang expert was qualified. Here it just said, this is important about the factors. The Daubert factors simply are not applicable to this kind of testimony from a gang expert whose reliability depends heavily on the knowledge and experience of an expert rather than on the methodology or theory behind it. Here, the extent of the officer's knowledge and experience was sufficiently probed, and the district court did not abuse its discretion. I'd also like to point the court to a case called United States versus Archuleta, ARCHULETA, 737 F3D 1287. That's out of the 10th Circuit in 2013. Specifically, what I'd like to point the court to in that is that in that case, the court found that the average juror is unlikely to be aware of those facts. Those were facts referred to structure and activity of the gangs. That's exactly what I'm saying here today. Although there are some people that might know that, that's absolutely not knowledge of the average juror, Your Honor.
A lot of your argument, though, Ms. Rosenwasser, focuses on on testimony that might be for a gang expert and for some of the factors that the court considers. I'm not saying, but you're going, do you have anything that's more recent that our circuits have done, the 11th Circuit or any other circuits post-enactment of our 702 and the Daubert requirement?
Well, Your Honor, the federal courts were operating under 702. So the Wilson case I gave you was Your Honor, was 2015. They were doing 702 before we were. We essentially just adopted their rule. So all of their holdings are going to be applicable here. And so a lot of these cases are fairly recent under the federal court. So I don't have anything from after we adopted that in 6 months ago.
Do you have anything from any of the federal circuits that interpret 702 or Daubert since then? Or recent pronouncements, like after 2020, let's say after 2020, 2021, 2022?
Your Honor, I can certainly provide that. The court. Give me a moment. But what I want to the law hasn't changed for the federal circuits. It's only changed for Georgia.
I understand that, Mount. I understand that. I'm not saying it isn't, okay, but there are some other civil and criminal cases that appear to interpret when you have a federal cases, that when you are talking about non-scientific areas of specialized knowledge, so the inquiry goes back to Kumo, and it says that the Daubert factors don't necessarily may not apply to testimony. It depends on the knowledge and experience of that particular area.
Mm-hmm. Yes, Your Honor.
And it references Hankey, which is a Ninth Circuit case, but it's you look at Daubert, Kumu, Hankey, 702. And for example, I'm looking at MedCorp versus Airmark Sports and Entertainment LLC. Entertainment Service LLC. It's out of the United States District Court of Arizona, April 23rd, 2021. It's a slip opinion. 2021 Westlaw 1597897, and it talks about Daubert analysis is applicable to testimony concerning non-scientific areas of specialized knowledge, Kumu. However, the Daubert factors may not apply to testimony that applies to knowledge and experience of the expert rather than a particular methodology, Hankey. Finding the Daubert factors do not apply to police officers' testimony, but they talked about that issue. But an expert qualified by experience may testify in the opinion if his or her experiential knowledge will help the trier of fact to understand the evidence and determine a fact and issue, as long as the testimony is based on sufficient data, is a product of reliable principles, and the expert has reliably applied the principles to the facts, 702 in Daubert. So, and of course, it does, the advisory committee that talks about amendments to 702 talks that vigorous cross-examination, presentation of contrary evidence, and careful instruction on the burden of proof for traditional and appropriate means of attacking shaky but admissible evidence under Daubert. But even though that's a civil case, it kind of gives me some roadmap in terms of what I'm supposed to look at in terms of non-scientific evidence, which this would be.
Yes, Your Honor. I believe Your Honor stated the factors exactly as I've stated them. I think that is the analysis. And I've just been trying to provide the court.
Well, how do we know he applied these correctly to this particular facts and circumstances? And I haven't heard any testimony about that. That's kind of, I've only heard one thing. I've heard that he made a statement to another, and as Mr. Jimenez mentioned a little earlier, you may have some foundational issues in regards to that, but I'm struggling whether or not he applied it to applied it correctly to Mr. Dorsey. Now, you haven't told me you needed this evidence for some other reason other than classification, and it hasn't been brought out in terms of that, but that's my concern with Mr. Hall.
Okay. Your Honor, I believe that, first of all, as I've stated, we have circumstantial evidence that he's reliably applied his methods generally, and the fact that no violence has occurred, that he's been doing the classifications correctly.
That's a stretch.
Your Honor, with these experts, it's different than when you have, for example, a scientific test, you put it in,
let's just say, as a general proposition, I'm glad that people who are in custody haven't been harmed in DeKalb County, but the fact that he's classified may or may not necessarily go to that particular issue. So.
Well, Your Honor, I think the fact that Mr. Dorsey, his ability to discuss that Mr. Dorsey is a member, that he was classified as a member of Sex, Money, Murder, and how they did that classification, I think that's absolutely how he applied his methods, and it was reliably done, and that can be inferred by circumstantial evidence. And it's different with these gang experts because they're essentially testifying about, they're not testifying about the results of an experience.
Did he testify that Mr. Dorsey was a member of Sex Money?
Your Honor, yes, he testified that they classified Mr. Dorsey as a member of Sex, Money, Murder. That was my belief about what he testified to. He also testified to that he listened to that he heard communication showing that Mr. Dorsey was a high-ranking member in the jail. That was the testimony that I recalled. And Your Honor, if the court would like me to provide additional case law, that I can,
I don't need more case law.
or if the court would like further questioning, we would have no problem with the court reserving ruling and revisiting this later should the court wish to recall him at a later time if the court feels that this is not ripe yet.
All right, just give me a minute.
Okay.
All right, I'm going to take the matter, I just need to take the matter of advisement. I'm going to hopefully make a ruling in, but after we have a comfort break. So, let's reconvene at 12 o'clock and then we'll go ahead and see where we are at that point in time, okay?
Okay, thank you, Your Honor.
We'll be in recess about 10 minutes. Say it again. Can you excuse me?
Mr. Williams. Okay, here's generally the way we'll proceed. I'm going to make a ruling on this in just a second. Ms. Rosenwasser, do you have the other two experts available?
Your Honor, I believe the court, when they put them on call.
Well, yeah, they're on call. They're available?
I mean, they have to get here, but I think they're going to be coming back.
All right, can you call them and tell them to be here for 1 o'clock? And we'll go ahead and take up those at about 12:30 or so. Those individuals in here who have not had lunch, who lunch is provided for, people in custody need to eat. So I'm going to go ahead and recess at 12:30 and let them eat. So if those two experts could be here by 1 o'clock, Mr. Tanner and Mr. Kilgore, I can take up those and we can clear those, and then I can spend the rest of the afternoon, depending upon how much time we need with your questionnaire. So that's my intent. Okay, all right. Okay, turning to the issue of qualification of Mr. Quentin Hall, who is sought by the state to be qualified as an expert in gang classification at the DeKalb County Jail. He has offered through counsel that he has been held that position for the past 3 years. He started his law enforcement career in 2014 as a detention officer. He has various trainings and certifications and classes through GIA, GIPSTIC. He's taken the gang identification classes. He is familiar with gang literature. He does cell searches. In terms of specific gang training, he has over 100 hours. He's listened to 1,000 hours of jail phone calls. He's familiar with gang tattoos. He's testified about some part or attempted to testify about the point system at the DeKalb County Jail in terms of some of the factors they utilize, but in terms of statements, gang leadership, tattoos, speech, flags. He's never been qualified as an expert. And I've heard, in making this ruling, I have considered the cases that the state cited for purposes of the record: U.S. versus Augustine, U.S. versus Wilson, U.S. versus Lobo Lopez, U.S. versus Ledbetter, U.S. versus Hankey, United States versus Thomas, and as well as the slip opinion in Medor versus Aramark Sports and Entertainment Service, LLC. These citations have already been provided on the record. The issue that the court has to, and with a non-scientific witness or expert, is to make sure that the knowledge and experience of that particular expert. And the qualified expert can testify in the form of opinion if his or her experiential knowledge will help the trier of fact understand evidence or determine a fact and issue, as long as the testimony is based on sufficient data, product of reliable principles, and the expert has reliably applied the principles to the facts of the case. The court further finds that this is the area of general knowledge that not necessarily, even though defense counsel has tried to intimate or make that, is not everyone in the public is aware of gang information. Not everyone is in the GGIA. That there's been testimony that false identification will get people harmed. But the question I posed to Ms. Rosenwasser, which still is not, I'm not satisfied as to as of yet, is that even though he's classified over 50 gang members, I have to be assured that he's reliably applied the principles and methods as to Mr. Dorsey. He couldn't explain the point system. I have a problem with that at this point in time. And even though he's testified that Mr. Dorsey's a member of Sex, Money, Murder, how did he specifically do this? I haven't heard testimony in that regard. So I'm unsure at this point in time from his testimony. So at this point, I'm not going to qualify him as an expert. However, I'll revisit that should the state repackage his particular he testifies more succinctly as to that. I'm not satisfied as of now. He's got a lot of experience, but I still have to be assured that he can apply that to Mr. Dorsey. And it may have just been, I don't know if he's nervous or if the questions he was asked or whatever else, but it's like you have to be able to testify, okay, these are the things that we in the gang expert, whatever, take a look at. We do X, Y, Z. My training tells me I do X, Y, Z, A, B, C, elemental P. As it pertains to Mr. Dorsey, I did A, B, C, D, E, F, G, X, Y, elemental P. Boom. He hasn't testified anything such as that. That's why I'm not going to qualify him at this point in time. I'll revisit it at a later point. Mr. Hall, you're doing a fine job. Don't want you to think you're not. I'm just not going to qualify you as an expert at this point in time. But State will get with you, and we'll see you at another point in time. Okay, sir? Don't discuss your testimony with anybody except the attorneys in this case. All right. Thank you.
Thank you, Your Honor.
All right. Ms. Jimenez, you get to write the order. So look at you. You get to write the order, okay? All right. Make sure you send that to Ms. Love and to Ms. Rosenwasser and let them take a look at it, okay? All right.
I'm sorry, did the court want orders on the other experts from this week? I can review those.
Yes, ma'am, I would. Okay. I thought you were going to go ahead and do that, but if I have not otherwise tasked you, yes, ma'am, I would.
Yes, Your Honor.
Okay, all right. Just bear with me a second. Bear with me a second. convene at 1:15, okay? And we'll go ahead and take your testimony at that point, and then we'll go ahead and talk about it very quickly. For those of you who have followed that, Mr. Kearns has sent out an somewhat updated questionnaire that I was trying to kind of manipulate earlier this morning. But it's the second one that we have sent out that I'm going to go off of this afternoon. So if you have it electronically, go ahead and pull that up. You can use that. Okay? All right. Unless there's anything else, we're going to recess until 1:15. All
I
right?
had one thing. Of course, Mr. Harvey celebrated his 49th wedding anniversary. And he's here.
Hold on, Mr. Harvey. I know from previous, I'm not talking about you.
But I'd also like to personally say that on behalf of him, I would like, the way things are going here, for next year on his 50th, that you give him the day off.
No. I can do that. Just because you asked. I mean, he's not taking, you and him are not taking CLEs anymore, so why not? We're too old to do that. I hope you get that.
You put that in there all the time.
All right.
Council, we get you done.
Whatever reason.
Sorry. Hey, man. Yeah. Yes, sir. No, they broke the rights. Yeah. Oh, yeah, I'm voting now. Yes. Right, but
Yes, yes. We need to go out.
Yes.